Yeah. Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes. I lost all feeling from my head to my toes. You said some shit that I can't let go, so just stay tuned for the rest of the show. So have you ever felt betrayed? Switches how you see things, realize something needs change. Cause I know you got me fucked up, let me show you what's up. Cause enough is enough. I'll take a face full of pavement just to make a statement. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll play it on your face to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go wish you would shut the fuck up real bad. And now that I'm gone, yeah, I know there's no turning back. And now that I'm gone, yeah, I know there's no turning back. I don't fucking take smoke, I'ma poke a hole through you, choking's overdue. Come at me and you won't get any older, dude. Crack your holder too. Heating up inside of me, blood so violently, thanks for trying me. Now it's finally time to see how this rivalry becomes a dynasty. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll play it on your face to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go wish you would shut the fuck up real bad. And now that I'm gone, yeah, I know there's no turning back. And now that I'm gone, yeah, I know there's no turning back. Yeah. Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like,
All rise. Court's now in session. Your Honor, Robert W. Hodges presiding.
Have a seat, everybody. I've shown the defense the list of juror numbers in the sheets I'm going to give them. Have you guys looked at them? They're up here. Take a look at them. So I'm going to give them their numbers now. I'm going to have Tracy, you deliver the numbers to them. I'm going to let them know that from here on out, I'm going to refer to them by number.
Judge, before the jury comes back, since the state and defense have rested, I'd like to review the motion for judgment of acquittal.
Yeah, I didn't forget. Just give me a second. No, she's not. She's just handing him the stuff, as far as I know. But if she starts to bring him out, I'll send him back. Has everyone looked at the instructions?
Yes, sir.
Is there any objections by anybody regarding the instructions?
No, Your Honor.
Okay. By the way, we're back on the record. State of Florida versus Susan Lorincz, 23 CF 2236. Is it possible I can maybe do this another time?
Yeah, I just heard that.
Okay. Yeah. Yeah, maybe like later, much later. That's okay. Thank you. 23 CF 2236. So everyone's looked at the instructions. Is that correct?
Yes, sir.
Does the state have any objections?
No, Your Honor.
Any additions?
No, Your Honor.
Does the defense have any objections?
No, sir.
Any additions?
No, Your Honor.
Okay. So I'm going to read to them in the order that we previously said. So the last thing I read will be the justifiable use of deadly force instruction. And then I'll read to them the closing argument instruction. So, Mr. Buxman, you're giving the closing argument?
I am, Your Honor.
Ms. Sizemore, you're giving the closing argument?
Yes, sir. I would ask that we take a short break after Mr. Buxman is finished, just so I can set up my stuff.
Yeah, no problem. We'll take a break after Mr. Buxman finishes.
Before the jury comes back, I'd just like to renew the motion for judgment of acquittal on the same grounds.
All right, Ms. Watson, what is the argument you want to make?
Judge, there's no additional argument, just the argument that I made previously.
Sorry, I can't hear you.
There's no additional argument, just the arguments that were previously made.
Okay. I remember the arguments that were made. I reviewed the case law you submitted. I'm going to deny the motion for judgment of acquittal on the same grounds I denied it at the middle of the trial.
Yes, sir.
All right, thank you. Everyone ready for the jurors?
Yes, sir.
So just listen to, before we bring him back, I'm going to bring him back. I'm going to go over with him as I always do, whether anyone has influenced them or they've spoken to anybody. I'm going to explain to them the numbering system, and then I'll read the instructions. When we're done with everything, then I will excuse the two alternates. However, I'm instructing everyone not to have any contact whatsoever with the alternates. Please don't speak to them. Please keep them in the same manner they were before. In other words, don't acknowledge them. I'm just going to excuse them from the courtroom. I'm going to instruct everyone in the courtroom not to have any contact whatsoever with the alternates. Don't ask them a single question, okay? I'm going to send them home and instruct the alternates not to look up anything about the case or discuss anything about the case until they've heard that the trial is over. Because there's always a possibility an alternate could be used, brought back into deliberation. So that's why I'm instructing everybody. An alternate, just so you know, if if something happens to a juror in deliberations, the alternate could be brought back in. But if someone talks to that person, then I can't bring the alternate back in. So I'm instructing everyone to leave the alternates alone. We'll get them back to their cars and then let them go home, okay?
Yes, sir.
All right. Let's bring it back, please.
Once again, for the record, I would urge the defendant is dressed in civilian attire as always and not handcuffed.
That's correct, and she is here and present. Thank you. Welcome back, ladies and gentlemen. Have a seat, please. As I've done before each day, I just want to ask you the same questions. By show of hands, has anyone contacted you about this case or said anything to you in your presence about this case? I see no hands. Have any of you contacted anyone else about this case or spoken about this case with other people? I see no hands. Have any of you gone online and looked up anything about this case in any sense whatsoever? I see no hands, and I appreciate it. The bailiff has given each of you a number, piece of paper with your name and number on it. That number will be used by you if jurors have questions or anything else. We're going to refer to you by number. So either keep your piece of paper or memorize your number, which shouldn't be that difficult. However, when final deliberations end, the verdict form has to be actually signed by the person. Don't sign with your number, okay? And we have a list of whose number, but otherwise you do have to sign it, okay? If you send a note to us, just use your number, all right? Listen carefully. I have your final instructions. I'm going to give you the first part of these instructions, which mainly deal with the offense and the defenses and all the elements that you need to know to understand their charges. Then they'll have their closing arguments. And the last part of the instructions really deal with how you go about your deliberations, okay? So please listen carefully. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Susan Lorincz, the defendant in this case, has been accused of the crime of manslaughter by use of a firearm. Susan Lorincz is accused of manslaughter by use of a firearm. Manslaughter is unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that Ajika Owens was killed by Susan Lorincz, you will then consider the circumstances surrounding the killing in deciding if the killing was manslaughter or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause the death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Susan Lorincz may be found guilty of manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Adjourns Owens is dead. 2. A. Susan Lorincz intentionally committed an act or acts that caused the death of Adjourns Owens. Or B. The death of Adjourns Owens was caused by the culpable negligence of Susan Lorincz. Every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life, or the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is the equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known, or reasonably should have known, was likely to cause death or great bodily harm. Aggravation of an offense by using a firearm. If you find that Susan Lorincz committed the crime of manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally used a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to, or may readily be converted to, expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find that Susan Lorincz committed the crime of manslaughter, but you are not convinced beyond a reasonable doubt that she personally used a firearm, you should find her guilty only of manslaughter. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Justifiable use or threatened use of deadly force. It is a defense to the crime of manslaughter by use of a firearm if the actions of Susan Lorincz constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Susan Lorincz does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. If Susan Lorincz was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent A. Imminent death or great bodily harm to herself, or B. The imminent commission of burglary, murder, or aggravated battery against herself. The crime of murder is defined as the intentional, unlawful killing of another by an act imminently dangerous to another and demonstrative of a depraved mind without regard for human life. The crime of burglary is defined as entering a structure owned by or in the possession of another with the intent to commit a crime therein. However, the crime intended cannot be burglary or trespass. Structure means any building of any kind, either temporary or permanent, that has a roof over it, and the enclosed space of ground and outbuildings immediately surrounding that structure. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. The crime of aggravated battery is defined as intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement to another. In deciding whether Susan Lorincz was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Susan Lorincz is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself when using defensive force that was intended or likely to cause death or great bodily harm to another if A. The person against whom the defensive force was used was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered a dwelling or residence, or if that person was attempting to remove another against that person's will from the dwelling or residence. And B. Susan Lorincz knew or had reason to believe that an unlawful and forcible entry or unlawful, And B. Susan Lorincz knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. A person who unlawfully and by force enters or attempts to enter another's dwelling or residence is presumed to be doing so with the intent to commit an unlawful act involving force or violence. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporary or permanent, or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides either temporarily or permanently, or is visiting as an invited guest. If you find that Susan Lorincz, who because of prior threats or difficulties with Adjourns Owens, had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Adjourns Owens, you may consider this fact in determining whether the actions of Susan Lorincz were those of a reasonable person. If you find that at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Adjourns Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed that it... Let me reread that paragraph. If you find at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Adjourns Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capabilities of Susan Lorincz and Adjourns Owens. Both the state and defendant have now rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. I just want to remind you that I will be giving each of you a copy of these instructions to take back with you when you deliberate. Mr. Buxman. Yes, sir.
May I have the access to the TV runner?
You ready to go? You ready for it?
Yes, sir. This case basically requires you as a jury to answer one question. Was it reasonable to shoot through a closed, locked, deadbolted metal door at someone who's banging and yelling on the other side? That's the ultimate question in this case. The evidence in this case that you've heard for the past several days has proven beyond any reasonable doubt that the defendant's actions were not reasonable that night. The judge just read the law to you that's applicable to this case, and it is that law that guides your decision in this case. It is that law that you must follow. It is that law that we as a society have agreed to live by, and you, by taking your oath as a juror, have agreed to follow. And that's the law that should guide your entire analysis in this case. As you heard, the defendant is charged with one count of manslaughter. And in order to prove manslaughter, the state has to prove the following two elements beyond a reasonable doubt. Number one, Adjoka Owens is dead. That is not in dispute. That was agreed by the parties. I'm not going to spend any more time on that. That's been proven beyond any doubt. Two, the state has to prove either that Susan Lorincz intentionally committed an act or acts that caused the death of Adjoka Owens, or B, the death of Adjoka Owens was caused by the culpable negligence of Susan Lorincz. The state only has to prove A or B, but the evidence in this case has proven beyond any reasonable doubt both of those. Let's talk about A first, that the defendant intentionally committed an act or acts that caused the death of Adjoka Owens. There is no question in this case that the defendant was the one that fired the gun that shot and killed Miss Owens. She was the only one in the apartment that night. You heard crime scene investigator Catherine Medina, who processed the inside of her apartment, went into that bedroom and found that .380 Remington firearm in the trash can beneath that .22 Ruger firearm. Catherine Medina also found the spent shell casing that was found on the kitchen counter. Dr. Norford, the medical examiner, removed the projectile from Miss Owens' body. And you heard from Florida Department of Law Enforcement analyst Jamie Williamson, who said she took that firearm that was found in the defendant's residence, compared it to the spent shell casing found in the kitchen, and determined that that casing was fired from the defendant's gun. She also examined that projectile recovered from Miss Owens' body and compared it to the .380 Remington firearm, the defendant's, and found that the projectile in Miss Owens' body was fired by the defendant's gun. Finally, the defendant admitted during her interview that she was the one that fired that gun. She also admitted that the act of pulling that trigger and firing that gun was an intentional act. It wasn't an accidental situation. It wasn't a situation where she slipped and fell and the gun accidentally went off and shot through the door and struck Miss Owens. That's not what we have here. She intentionally fired it. There's no doubt the defendant intentionally committed an act which caused the death of Adjoka Owens. And we also know that Miss Owens died as a result of that gunshot wound. The state's proven this beyond any reasonable doubt. You heard the judge read an instruction. You may be back there thinking, well, what if the defendant didn't intend to kill Miss Owens? Well, the judge has told you that that is not an element, that's not a requirement for the state to prove in a manslaughter charge that the defendant intended to kill Miss Owens. She's not charged with first-degree premeditated murder, which would require an intent to kill. She's charged with manslaughter. The judge told you that in order to convict of manslaughter, it's not necessary for the state to prove the defendant had an intent to cause the death. We'll get into what the state only has to show that the act was not merely negligent, justified, or excusable, and we're going to get to those terms in a few minutes. Because element A of Part A of element 2 has been proven beyond any reasonable doubt, there's no even need to get to B. However, the evidence has also proven that the death of Adjoka Owens was also caused by the culpable negligence of the defendant. The judge read to you a long instruction about culpable negligence, told you that each of us has a duty to act reasonably towards others. In order for negligence to be culpable, it must be gross and flagrant. It has to show a reckless disregard for human life or the safety of people exposed to its dangerous effects. It has to be committed with an utter disregard for the safety of others. The evidence has proven that the defendant did act with utter disregard for the life of others. She pointed a loaded firearm towards a door, towards a person that she knew was there on the opposite side of the door, and intentionally pulled the trigger. That shows a reckless disregard for human life. It's an act which she must have known or reasonably known would cause death or serious bodily injury if that projectile struck somebody. The evidence has proven beyond any reasonable doubt that the act of firing that gun constitutes culpable negligence. The crime of manslaughter has been proven beyond any doubt whatsoever, ladies and gentlemen. The question in this case lies with whether or not she was allowed to shoot and kill Miss Owens under these circumstances. The law says that in certain circumstances, a person cannot be held liable or responsible for shooting another person. And the first situation is if the killing was excusable. The judge read to you this instruction a few minutes ago. I'm not going to read the whole thing. But in order for a killing to be excusable, the killing in each of those three situations has to be committed by accident. And we've already discussed that this was not an accidental discharge. It's not a situation where she was playing with the gun and it accidentally went off and shot through the door, or she dropped it. This was an intentional act. So excusable homicide is not relevant in this case. Another way in which a person could not be held legally responsible for killing another is if the killing was justifiable. You heard Judge Hodges read a few minutes ago that the killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant or commit a felony in any dwelling house in which the defendant was at the time of the killing. That is the general instruction on justifiable homicide. The judge read to you a longer, more detailed instruction, which is what I'm going to go over now. Judge Hodges explained to you that if the defendant was in a dwelling or residence in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent either A, imminent death or great bodily harm to herself, or the imminent commission of a burglary, murder, or aggravated battery against herself. That first sentence there, if she was in a dwelling or residence in which she had the right to be, she had no duty to retreat. That applies in this case, ladies and gentlemen. The defendant was in her own home. The law accounts for that because people do have a right to be in their own home and be safe in their own home. That applies in this case. The law does not require her to jump out the back window and retreat in order to avoid this because she is in her own home. She doesn't have to do that in order to claim that she acted in self-defense. Now, her actions inside of her house and what she does during this period of time is relevant to look at the reasonableness of her fear and the reasonableness of her actions and decision in making and shooting. But she is not required to try to jump out a window to avoid this before she can claim self-defense. The crux of this case, ladies and gentlemen, is whether at the time she fired her gun at that closed, locked, deadbolted door, did she reasonably believe that her conduct was necessary to prevent imminent death or great bodily harm against her, or the imminent commission of burglary, murder, or aggravated battery. The instructions that the judge read to you gives you an explanation of what burglary, murder, or aggravated battery mean legally. And I'm going to go through those later on. He read them to you, so I'm not going to go over them again right now, but we're going to address those later on. The judge also explained to you that in deciding whether the defendant was justified in using deadly force in firing that gun, you have to consider the circumstances under which she was surrounded at the time she chose to fire. Judge Hodges explained to you that the danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real the defendant actually believed the use of deadly force was necessary. Well, what does it mean by the danger need not be actual? Well, if the bailiff here and I are getting into an argument and I start getting heated and I start walking towards her and I pull out a gun and she pulls out a gun and shoots and kills me, but my gun was a fake gun, my danger to her wasn't actual. But all the circumstances surrounding it made her think that it was. So the actual danger need not be actual. But the defendant actually had to reasonably believe that the use of deadly force was necessary to prevent an imminent harm to herself. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. The standard by which you review this is based on whether a reasonably cautious and prudent person under the same circumstances the defendant would have felt the danger was necessary. You take a normal, average, everyday person and ask yourself, would that normal, average, everyday person under these circumstances have believed that it was necessary to use deadly force to prevent the imminent harm to themselves or the imminent commission of a burglary, murder, or aggravated battery? I've used the word imminent many times because that's in all of these definitions, and that's very important. It's not that something bad could happen in the future or something may have. That something bad has to be imminent, immediate, about to happen. So let's start with whether or not the defendant reasonably believed that her firing the gun was necessary to prevent imminent death or great bodily harm to herself. What were the circumstances she found herself in at the time she chose to pull that trigger? Because that's the relevant time. When she makes that decision to pull that trigger, what are the circumstances surrounding her? That's what the law focuses on. Taking a step back, though, we know that there have been past issues between the defendant and Ms. Owens. We've heard about a couple issues during the testimony and the evidence that they had some conflict in the past. That information is relevant to you, could be relevant to you, to consider, because those past contacts between the defendant and Ms. Owens could factor into the reasonableness of her decision in pulling the trigger. They may not. But the judge read to you, if you find the defendant who, because of threats or prior difficulties with Ms. Owens, had reasonable grounds to believe she was in danger of death or great bodily harm at the hands of Ms. Owens, you may consider this fact in determining whether the defendant's actions were those of a reasonable person. I want to talk a little bit about those prior issues. We know that these prior run-ins were the result of the defendant acting out or doing something towards the victim's children, Isaac and Israel. And at the time, we heard that Isaac was about 12 years old, Israel was about 9 or 10 years old. We heard that the defendant complained about the children, complained about them playing in this field, this open lot next door to her house. You heard that these children would play in that open field. They played football, they played some bottle game and some running around, what kids do. They weren't breaking into cars, they weren't vandalizing.
So ruled. Go ahead.
They weren't causing problems, vandalizing things, they were playing. And you heard from Frank Colon, who told you he was often out there playing with the children regularly to make sure they behaved. But as children do when they're playing, especially in groups, the children got loud. The children yelled and screamed and played. They did what kids do. The defendant, the evidence has shown, didn't like that. She told the detectives in the interview she works from home. The loud noises interfered with that ability. She didn't like it. She complained to Charles Gabbard, her landlord, and Charles Gabbard, in response, in order to pacify her and appease her, got some no trespassing signs, those little signs that you get from Lowe's or Home Depot, and put them in the ground. She complained to the police about the children when she would call, complaining that the children were too close to her property or trespassing on her property or leaving things on her property, toys, and that they were loud. It's important to note that Charles Gabbard owns the property the defendant lived in, but he does not own that open field where the children played. Charles Gabbard has no ability to tell those children don't play there, or tell the children to be quiet, and neither do the police. You heard on two prior occasions that there were some prior difficulties between the defendant and Ms. Owens. You heard on one occasion, which happened February 25th of 2022, about 16 months prior to the shooting, that the defendant was again upset about the children playing, being loud, doing what they were doing. And you heard from London Remy, the 13-year-old girl that testified on the first day of this trial, that Ms. Owens walked over to the defendant's area, and there was an argument between the defendant and Ms. Owens. Ms. Owens went over there to tell the defendant to stop yelling and treating her kids the way that she was. There was an argument, and Ms. Owens pulled the no trespassing sign out and tossed it at the defendant as she was walking away. You heard London Remy talk to you about that. And she explained and even demonstrated how Ms. Owens took the sign and tossed it as she was walking away. And that sign hit the defendant in the leg. Was that the proper way of probably handling the situation by Ms. Owens? Probably not. But what's important to know is there were no punches thrown, Ms. Owens didn't run up and attack the defendant, didn't punch her in the head, knock her down, kick her, didn't, bust into her house or anything like that. Ms. Owens said what she had to say, tossed the sign, and walked away, leaving the confrontation. The defendant called 911, the emergency line. The officers came out, talked to everybody, and no arrests were made. On another occasion, December 22nd of 2022, about 6 months before this crime, the defendant was again angry at the children for being loud. Obviously, the children told their mother because, again, Ms. Owens came over to the defendant's property and told the defendant not to yell at the children. We heard from Deputy Kinsey, who spoke with Ms. Owens, and Ms. Owens told Deputy Kinsey, I walked over there with my child and wanted to talk to the defendant and deal with the situation. According to the defendant, the victim told her that if you yell at my kids again, I'm going to drag you out and beat your butt, basically. But remember in the defendant's second interview that you heard with the detectives, she was specifically asked if she remembered any kind of threats like that. And the defendant said she didn't remember anything. So either Ms. Owens never made such a statement, or the statement wasn't so significant such that the defendant even remembered it to talk to the detectives about it when specifically asked. And we also know that the defendant, moving ahead to the night of the shooting, the defendant tells the detectives that Ms. Owens came over and said, I'm going to effing kill you, over and over again. No one else heard that. You heard from Jared Gardner, you heard from Ariel Rodriguez, who were right there. They said she never said that. So back to February of 2023. We know that Ms. Owens was upset about how the defendant was talking or treating her children. Ms. Owens walks over to the defendant's property. They have this argument, disagreement, whatever you want to call it. There's no violence. There's no punches thrown. Ms. Owens doesn't knock the defendant down and kick her and beat her. She doesn't try to break into her house, shatter her sliding glass door to get to her, nothing. It's a verbal argument, and the verbal argument ends when Ms. Owens walks away from the situation and goes back to her house. The defendant again calls 911. The police come out. They interview everybody. No arrests are made. As I said earlier, you can consider these prior difficulties between the two in determining whether or not they contributed to the defendant's decision to fire that gun that night on June 2nd, 2023. I submit to you that these two episodes, one of which happened about 16 months before the shooting, one happened about 6 months or so before the shooting, involved no violence except for the tossing of a sign, a flimsy Lowe's no trespassing sign. They didn't involve the defendant or the victim trying to break into the defendant's house. Didn't involve Ms. Owens beating the defendant up or causing her any physical injuries, and were resolved when Ms. Owens walked away from the confrontation. Now, it's interesting in her interview, in the defendant's interview, that she described an incident that happened about 2 months before the shooting on June 2nd, after the sign throwing incident, after the second incident that happened in December of 2022. She described an incident that happened about 2 months before the shooting. Now, the defendant in her interview tried to explain how this sign throwing incident and this other incident caused her such terror of Ms. Owens, such fear, such panic, because Ms. Owens was so violent that contributed to her, the reasonableness and why she decided to fire the gun. But let's talk about what the defendant said in her interview about the incident that happened 2 months prior to the shooting, after these other things. She's talking to the detectives about the sign throwing, or about this incident that happened 2 months before, and she tells the detectives, and one time she was talking to the neighbors, meaning the defendant, or meaning Miss Owens, and she said, oh, that bitch over there is crazy, I'm not going, sorry, I walked over. I said, what is your problem? And she just went on a tirade. She tells the detective, I walked over and said, what is your problem? The defendant admitted that she was the one that walked over and confronted Miss Owens about Miss Owens telling a neighbor that the defendant was a crazy bitch. And she told the detectives further that she was actually over by Miss Owens' driveway when she confronted Miss Owens. Does that sound like the actions of someone who was so terrified because somebody tossed a no trespassing sign and someone came over and had an argument with her earlier? Does that sound like somebody who's so afraid of this woman that she's going to walk up to this woman, confront her in her own driveway? Or does that sound like someone who is angry at Miss Owens and has no problem initiating confrontation? The defendant also explained that during this same incident, two months or so before the shooting, that Miss Owens accused her, the defendant, of using racial slurs towards her children. The defendant during an interview explained, look, I told her I didn't do that. She kept insisting I did, and the defendant said, I eventually just said I'm sorry to diffuse the situation. There is probably nothing more infuriating to an African American woman.
Objection, improper argument.
So overruled.
There is probably nothing more infuriating to an African American woman for someone to believe that someone used a racial slur towards her children. But what does Miss Owens do when she thinks this is what happened? She doesn't go over and attack the defendant, she doesn't go over and beat the defendant up. She doesn't go and attack Miss Lorincz, push her down, and say, this is what you told my children. She goes and she has an argument. And Miss Owens doesn't resort to violence. Miss Owens walks away. Miss Owens, if she wanted to, had every ability to attack the defendant for that. But she didn't. She had every ability because even then, there wasn't a closed, locked, deadbolted metal door between them. Despite not having that barrier, Miss Owens did not do anything violent towards the defendant. Instead, she walked away without incident. Which brings us to June 2nd, 2023, the day of the shooting. We saw videos taken from the defendant's cell phone during the couple hours before the shooting happened. They showed the children playing in that open field. You saw Frank Cologne out with the children one time in one of those videos. And in one of those videos, taken at 8:49:51, we see Israel waving past the trespassing signs on her property, waving at her. Once again, the defendant was angry because the children were being loud and it was bothering her, and Israel went past the no trespassing sign. And you heard from Uriel Rodriguez, who said, yes, in fact, that night, Israel did go past the no trespassing sign. We saw that in the video we just looked at. We heard from the defendant's 911 call in the interview with the detectives that there was some altercation between the defendant and Miss Owens' children. It involved a tablet, roller skates being thrown, an umbrella being shaken, something. The facts of that altercation really aren't important or relevant. What's relevant is that that is the catalyst, that is what causes the children to go and tell Miss Owens. And that's what causes Miss Owens to come over and once again deal with an issue regarding the defendant and her children. We heard from the 911 call that the defendant made, the first 911 call before the shooting, and she acknowledged there was an issue with the children. She acknowledged that she threw some roller skates. She acknowledged and told the 911 operator that the child accused her of stealing the iPad. We heard in the 911 call that, in the interview, that there was something involving shaking an umbrella as well. So we know that the defendant got into some sort of argument or something with the children, which caused the children to go talk to Miss Owens, their mother, and causes Miss Owens to come over to deal with it. You heard from Jesse Newbanks, the Marion County Sheriff's Office digital forensic examiner who examined the defendant's cell phone. And going into the logs of the cell phone, we know that the defendant first made that first 911 call that we heard at 8:54:09 p.m. And you heard her on that call. That was played earlier. You heard her. She was angry about the children trespassing, angry about that 9-year-old stepping onto her property, angry about the children leaving things in her area. She was angry the kids were being noisy. And she admitted to throwing the roller skate like we saw in the photo a few minutes ago. She told the 911 operator that she was sick of the children. Her words were, "They are bothering me. They won't effing stop." She wasn't afraid. She was angry. You heard the tone of that 911 call. The 911 call, an operator asked, "Are you in danger?" She said, "No, I locked my door." She locked her metal door. We know from her 911 call, the main lock was engaged. We know from her interview with the detectives, the deadbolt was engaged. So at this time, she is behind a closed, locked, deadbolted metal door, standard metal door, about 1 3/4 inches thick. She's behind that in her concrete block home. Now, let's take a pause from June 2nd. You heard some information about the door jamb having some prior damage to it. And we saw photos, the state introduced photos of that door jamb and the prior damage. We heard from the landlord, Charles Gabbard, who said, yes, that door about a couple months earlier had some damage to it. I went and repaired it. He told you he replaced the strike plate of the lock, he replaced the strike plate for the deadbolt, he drilled those things into the door frame, and it was secure. He used some wood putty to further secure it. And the only thing that was left was some cosmetic damage that didn't affect the integrity or the stability or the durability of that door. He told you that when he left, the defendant was content with his repairs, except for the cosmetic damage, which he said, "I'm going to come back and make it look pretty." But that door was secure. There was no concern at all that that door wasn't going to hold up if someone banged on it. So we talked about the first 911 call was made at 8:54:09 p.m. And based on Jesse Newbanks' analysis, that call lasted 4 minutes and 55 seconds, which means she hung that phone up at 8:59:04. At 9:01 and 37 seconds is when the data on her phone says she picked up the phone again to call 911 after the shooting happened. So whatever happened with Miss Owens coming to the door, banging on the door, the defendant going in to her bedroom, getting the gun, coming out, aiming at the door, shooting, and then her getting her cell phone and making a call, took 2 minutes and 33 seconds. Not the 10 minutes like she told the detectives. 2 minutes and 33 seconds. So again, the evidence has shown that before she makes the second 911 call, Miss Owens walks from her house across the street to the defendant's house to deal with the situation involving her children. Witnesses said she walked over there with purpose. She was mad, no question. Jared Gardner told you that he heard Miss Owens say, after she's banged on the door, something to the effect of, "Come out here, bitch," or "Bitch, open the door," something to that effect. Jared Gardner told you he never heard Miss Owens say anything like, "I'm going to effing kill you," "I'm going to break down your door," "I'm going to go in your house." He didn't hear anything like that, because those statements weren't made. He heard Miss Owens tell the defendant, "Come outside." You heard from Uriel Rodriguez, 12-year-old Uriel Rodriguez, the second witness we called. He told you he saw Miss Owens walk across the street, saw her walking with a purpose, saw that she was angry, it was clear how she was walking, saw she didn't have anything in her hands. He heard Miss Owens say, "Come out." And he said she used the B word and the F word, consistent with what Jared Gardner said. So he too hears Miss Owens say, "Come out, bitch." Uriel Rodriguez said he never heard Miss Owens threaten the defendant, say, "I'm going to F and kill you, I'm going to bust in your house," anything like that. It was "come out." Ms. Owens made it clear to the defendant that she wanted the defendant to come out and deal with this situation. If Ms. Owens wanted to get into that house, all she had to do was take something from the patio, that little Santa thing that was sitting there, throw it through the sliding glass door, shatter the door, and get in there. She didn't do any of that, because her goal was not to get in the house. It was to get the defendant to come out and deal with the situation with her children. Even in the defendant's interview with the detectives, she was asked what was the first thing that came out of Miss Owens' mouth. And the defendant said, Miss Owens first said, "I want to speak to you because you're talking to my sons. I don't like the way you're talking to my sons." First thing out of her mouth deals with her sons. First thing out of her mouth is not, "I'm going to bust in your house and I'm going to kill you." It's, "I want to talk to you about my sons," just like the last times. You heard from Yvonne Costa, who's the neighbor, had the joining wall to the defendant's apartment. She told you that she heard arguing, loud arguing, and then she heard a door slam. Clearly, this was the defendant slamming her door after she was arguing with the children, because Yvonne Costa said a few minutes later is when she hears the pounding. And the pounding was loud. There's no doubt about that. It was loud enough to shake the wall between the two of them that they share, and maybe even rattle a mirror. It was loud. But it wasn't banging hard enough to damage the door. There's no dents. There's no major problems with the door. No damage to the doorknob as if someone was trying to beat on it and break the doorknob off to get in there. She was banging hard like law enforcement officers do when they come to a door and say, "Marion County Sheriff's Office." And in fact, the defendant actually told the detectives she initially thought it might be the law enforcement coming. Why? Because she just called them and knew they were coming. She knew they were coming before she fired the shot. Everyone then, after the banging, hears the shot. You heard the interviews the defendant gave and the 911 calls. The defendant never said that Miss Owens was rattling her doorknob, shaking the doorknob as if she was trying to get in. She was specifically asked during the second interview, did she ever try to open that sliding glass door or open the door handle or anything like that? Or was it just pounding? The defendant's answer was, "I just remember her pounding and pounding." You also heard in the interview that the defendant gave that the sliding glass door was further secured by a wooden stick in the track, so the door couldn't be opened. It was locked, the door couldn't be opened because of that wooden stick. The defendant never told the detectives during the interviews that Miss Owens was trying to open that sliding glass door, that she was banging or jiggling on the doorknob trying to get in. Never told them that she was trying to break her window or anything like that. Rather than wait for law enforcement to arrive, because she knew they were coming, because she called and they told her that law enforcement was coming, she went into her bedroom and grabbed her gun. She doesn't grab her phone, which she just had in her hand 2 minutes earlier, to call 911 again. She goes in the bedroom and grabs her gun. She goes back into the family room. She approaches the door to the point where she says she reached that kitchen table. She doesn't fire a warning shot through the door or in the air, into the ground, anything like that. We heard her in her first interview say she never intended to kill Miss Owens. Well, look at the placement of the shot that she fired. She took aim. She leveled the gun at the door. She aimed directly where a person would be if the person was knocking on the door, at a height consistent with where Miss Owens would be, and pulled the trigger. She didn't fire over and over and over again. She didn't unload her magazine as if she was in a panic. She fired one controlled, precise round into the door at the exact place a person would be if they were knocking. Then she had the presence of mind to go back into her bedroom, put that .380 Remington back in the trash can, underneath the .22 caliber Ruger that was found, because remember, CSI Medina found the .380 gun, the gun that used to fire the bullet in this case, beneath the .22 caliber Ruger, the little plinker. And then she has the presence to call 911. So now that we know what the evidence has shown, let's go back to the instructions that we looked at earlier. The circumstances that she found herself in when she fired that round were that she was angry at Miss Owens' children, such that she called 911 on the children. That an angry mother was banging on her door, yelling at her to come outside. that she is behind a closed, locked, deadbolted metal door, and she knows law enforcement is on the way. She goes into her bedroom, she grabs her gun, walks back to the living room, walks towards the door, fires one precise round in the exact location where a person would be. Those are the circumstances by which she was surrounded when she made that decision to pull the trigger, at the time she decided to use deadly force. There was no imminent danger whatsoever when she fired that gun. Ms. Owens had not broken down the door. She hadn't gained access to her house. She hadn't shattered the sliding glass door to get in. Ms. Owens was banging on the door, telling the defendant to come out. A belief that there was an immediate or imminent danger such that deadly force was necessary at that time was simply unreasonable, because there was no imminent danger. And that word imminent is very important. It's included in the law for a reason. In order for the defendant to be allowed to use deadly force, that threat to her life must be imminent. It had to be ready to happen. It had to be staring her in the face, such as she had to act at that moment to protect her life. If Ms. Owens would somehow have managed to bust through this locked, deadbolted metal door, entered her house, and started coming at her, the defendant may have had a right to shoot, because that danger would have then been imminent. But that's not the situation we have here. We talked about Part A, imminent death or great bodily harm to herself. She would also have the right to use deadly force if she needed to do so to prevent the imminent commission of a burglary, murder, or aggravated battery against herself. Murder is defined as the intentional, unlawful killing of another by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Again, there's no evidence to support that at the time the defendant fired that gun, that Ms. Owens was about to murder her. Ms. Owens had no ability whatsoever to even get into that house, to even try to cause her harm. There is the secure, locked, deadbolted metal door. It's not a situation where Ms. Owens was charging at the defendant with a gun, a bat, a knife, something like that, and she had to resort to use deadly force. That's not our situation. Similarly, the crime of aggravated battery is an intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement. Just like the previous explanation, Ms. Owens, at the time she was shot, had no ability whatsoever to even get into that house. It also is interesting to know that at no time during the interview does she claim to think that Ms. Owens had any kind of a weapon. There's no evidence to support that Ms. Owens was in the process of committing an aggravated battery or about to cause her imminent, immediate harm when she fired that gun. Let's talk about burglary. The defendant would be allowed to use deadly force to prevent the imminent commission of a burglary upon herself. Well, what is burglary? Burglary is entering a structure owned by or in the possession of another with the intent to commit a crime therein. And the crime can't be burglary or trespass. The judge also read you the definition of structure. It means any building of any kind, temporary or permanent, that has a roof over its head and the enclosed space of ground and outbuildings immediately surrounding the structure. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. Based on the law, there is no doubt the inside of the defendant's house is a structure. This is a situation where Ms. Owens is standing on the other side of the door, yelling at the defendant to come outside. There's no evidence whatsoever that Ms. Owens was trying to enter her residence. She's not jiggling the doorknob. She's not, shattering the sliding glass door or anything like that. There's no evidence that Ms. Owens said anything to indicate she was going to bust into her house. No evidence that Ms. Owens was committing a burglary of getting into her house or trying to get into her house. Also included, though, in the definition of structure includes the enclosed space of ground and outbuildings immediately surrounding that structure. That would include the defendant's porch area. The evidence has shown that Ms. Owens walked onto her porch area, the defendant's porch area, to bang on that door. So Ms. Owens did enter that portion of the structure, that porch area. But what's important about burglary is that second sentence up there in the first paragraph. Or the first sentence, I'm sorry. In order for something to be a burglary, the person would have to enter the structure with the intent to commit a crime. That's why the mailman or the Amazon delivery guy can come onto the porch and drop off a package and not be charged with burglary, because there's no intent to commit a crime. Also important is the crime that is intended to be committed cannot be burglary. Obviously, you can't use the charged crime with the intended crime to be the same, and it also can't be trespass. The crime has to be something other than Miss Owens walking onto that porch, by the law that we all have agreed to live by. That crime that intended to be committed to be a burglary could be theft, could be vandalism, could be some violent crime towards a person, but it cannot be simply walking onto that porch. So if you're thinking, well, Miss Owens walked onto the porch, therefore she intended to commit a trespass, therefore it's a burglary, therefore the defendant has the right to shoot, that would be legally incorrect. And that would be a miscarriage of justice. It's legally insufficient for that to constitute a burglary. In order for the defendant to have the right to shoot Miss Owens, there has to be it has to be done to prevent the imminent, immediate, about to happen commission of a burglary. And that burglary would have to be that Miss Owens came on the property with the intent to commit some crime. Miss Owens came onto the property to have the defendant come out to discuss this issue. It's not a crime to bang on somebody's door. It's not a crime to yell. There is no evidence that she came over there with any other intent but to get the defendant to come out and talk. That's why Miss Owens' actions don't constitute a burglary. The judge also read to you an instruction that Susan Lorincz is presumed to have held a reasonable fear of imminent peril, of death or great bodily harm to herself when using defensive force that was intended or likely to cause death or great bodily harm if these two things happen. The person against whom the defensive force was used, in this case Miss Owens, she was the one that the force was used against, was in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered a dwelling or residence, or if that person was attempting to remove another against that person's will from the dwelling. And the defendant knew or had reason to believe that the unlawful and forcible entry or the forcible act was occurring or had occurred. Notice what this instruction requires. The person was in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered the residence. Not that the intruder may want to come in or could come in. The intruder has to be in the process of entering the residence or in the residence. We don't have that here. As we discussed, there's no evidence whatsoever that Miss Owens was actually in the process of unlawfully or forcibly entering the house. The defendant is not entitled to any kind of presumption that she was in fear. Based on the law that we went over and the evidence and circumstances surrounding the defendant when she chose to fire that gun, which killed Miss Owens, her actions were not reasonable, and she was not allowed to use deadly force legally, based on the law. Now, you heard from a crime scene expert, Joshua Wright, who explained where he thought the defendant was standing when she fired the gun in the house. You heard from a computer graphics gentleman who did the video that we saw and some of the photogrammetry information that was yesterday. And those representations relied heavily on what the defendant said happened, her own version of events. You also heard from Roy Bedard, who talked in generalities about how people make decisions in stressful situations. Ladies and gentlemen, none of that testimony sheds any light on the reasonableness of the defendant's decision or the imminence of the threat that she perceived. Ladies and gentlemen, because the evidence has proven beyond any reasonable doubt that the defendant's decision to use deadly force by pulling that trigger And because her intentional act of firing through that door caused the death of Ajika Owens, we're asking you to find the defendant guilty of manslaughter with a firearm. Thank you.
Ladies and gentlemen, we're going to take a short break, about 10 minutes, and then we'll come back and hear the defense closing argument. Welcome back, ladies and gentlemen. We will now hear from Ms. Sizemore.
May I please report?
Yes, ma'am.
Counsel? Good morning. This case is about perception. The Constitution of our country embodies the right to be able to defend ourselves. And there's a wisdom in our laws that begins with this concept of perception. It's central to self-defense because the law protects that reasonable perception. The law demands that we assess the reasonableness of that perception, not from the comfort of a courtroom. But we have to take ourselves back to the perspective of the moment itself. The law requires each and every one of us to look at the circumstances that Susan Lorincz was facing on June 2nd of 2023. She was almost 59 years old. She was in her home where she lived alone, a troubled neighborhood to say the least. It was nighttime. She was suffering from a multitude of medical conditions when she was startled by a barrage of screaming of profanities and banging on her door so hard that the walls were shaking in a cement block house. Now, the judge has gone over with us some of the law in this case, and it's very, very important, particularly when we are dealing with self-defense. And I know Mr. Buxman went over a little bit. I need to go over it with you, and this is the only opportunity that I have to speak with you, so just bear with me. In jury selection, the judge talked to us about this plea of not guilty and reasonable doubt. He sort of went over that instruction, and he gave it again, and there's a reason that it's one of the first instructions that we get. It's sort of the foundation of our system of justice. So what does it tell us? It tells us that Susan Lorincz has entered a plea of not guilty. This means you must presume or believe that she is innocent. So we start there. We start with the fact that she's innocent, and where does it go? Where does that presumption go? It stays with the defendant as to each material allegation in the information through each state of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. That's pretty powerful language for the protection of our liberties. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. We talked about this term reasonable doubt in jury selection. I'm not going to read the whole definition to you again. The judge gave it to you again. And it's very important. And what is reasonable doubt? It means you have to be sure. Really sure. The law says you should only convict someone if you're convinced they're guilty beyond a reasonable doubt. You should feel confident in your decision without hesitation. So if there's something in the evidence that gives you pause, if you're back there and you're deliberating and you're thinking, man, she was an older woman, she had some medical issues, she did live alone, she had these prior run-ins with Adjourns, I could see how she could be scared of her. And you're thinking, I did see the damage on that door. That's reasonable. I could see how she could be afraid that she was going to get through. If you're back there and you're pausing and you're hesitating, if you're wavering and vacillating, that's reasonable doubt. And if you have a reasonable doubt, you should find Ms. Lorincz not guilty, because that is what the law says. And each and every one of you took an oath to follow the law. So where do we look for reasonable doubt? It is to the evidence introduced in this trial, and to it alone. Only the evidence introduced in this trial and nothing else, that you are to look for that proof. It may arise from the evidence, the conflict in the evidence, or the lack of evidence. And if you have a reasonable doubt, you should find the defendant not guilty. Justifiable use or threatened use of deadly force. This is a very, very important jury instruction. You're going to get to work with this when you're deliberating. The laws in Florida give citizens the right to defend themselves when they are faced with imminent danger. Deadly force means force that is likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. And the most important thing in this part of the jury instruction is where it says, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. So they not only have to prove to you that she committed this manslaughter, but they also have to prove to you beyond a reasonable doubt that she was not justified in using deadly force. Now, Mr. Buxman went over this, Judge Hodges read this to us, and there's a couple important parts of this jury instruction that we need to focus on. And one is, if Susan Lorincz was in a dwelling in which she had a right to be, she had no duty to retreat. If you remember during the trial, Mr. Smith had asked some of the witnesses, did Susan shoot from way back there by her bedroom? Did she shoot from behind that countertop or behind that kitchen? It doesn't matter, because she has no duty to retreat, and she can stand her ground when she is in her dwelling if she is faced with imminent danger. Another important part of this is if she reasonably believed. We do not judge Susan Lorincz with what we in this courtroom have experienced in life. It's not what I would do, or Mr. Buxman or Mr. Smith would do in that circumstance. It's what Susan Lorincz reasonably believed was necessary to prevent. That's a very important word, prevent. The law does not say that you have to wait to get punched or attacked before you can do something. That's not what it says. You can use deadly force to prevent someone from coming into your home and hurting you or attacking you. Because members of the jury, if someone who is on the outside of your door that is banging and pounding so hard wants to get in that house and they do, it is too late. There are way too many variables if someone actually gets inside. Your gun could jam. You could get rushed. You could fall, especially if you have medical conditions. So the law accounts for that. You can do what you need to do to prevent that from happening. What was Miss Lorincz confronted with on that night when she had to make a split-second decision? We heard from Dr. Roy Bedard. He's a world-renowned use of force expert, trains law enforcement officers all over the country, and he talked to us about how someone reacts under stressful situations, these high-stakes decision-making, and he told us that when there's high consequences, you don't really know if the person on the other side of the door or the person that's confronting you is armed. Not just Susan Lorincz, but most people go to the fact that this person is armed, that they are a real threat. That's reasonable. And Susan Lorincz had no idea what Adjourns Owens had on her. He told us that biologically, and what happens in your brain and you're stressed, and you have these high anxiety situations, and it's releasing all of these things, your adrenal glands, and it's a high stress situation. And people have to make life or death split-second decisions when they're going through these things. He told us how a person perceives time differently. That something that was a second may have actually been a minute. And he told us that if someone's older, or if they have prior negative dealings with somebody, all of those things can affect their decision making. It's very difficult for someone to judge what is going to come next. And the law says that Susan Lorincz can defend herself to prevent the imminent commission of burglary, murder, or aggravated battery against herself. So this sort of lays out the definition of those things, and I'm not going to read it all again. But there's an important thing that I want to point out about the crime of aggravated battery. It's defined as intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement to another. We heard from Dr. Norford, the medical examiner in this case. And on cross-examination, she told us, if somebody is hit or kicked or punched, and that person is older, and they have medical conditions, that could cause great bodily harm to them. So if Adjourns Owens gets through that door and just punches or kicks or hurts Susan Lorincz, that could cause her great bodily harm. We heard the statement that Susan Lorincz gave to law enforcement. We heard two of them. And Miss Lorincz told detectives on the night of that incident Miss Owens was pounding on her front door so hard the walls were shaking. She told detectives that Miss Owens was screaming at the top of her lungs, and that Susan told her, "You're trespassing, you need to leave." Susan Lorincz told detectives, "I really thought she was going to break my door down. I really thought that. I saw the door moving in, and I really believed that. I honest to God believe that." That is what she said. She reasonably believed that. We heard Susan tell the detectives, "I heard Miss Owens say, 'I'm going to fucking kill you.'" She heard that. Miss Lorincz told them, "I heard the door crack. And when I heard that door crack, I fired." We heard from Joshua Wright, the ballistics expert, and he sort of worked in conjunction with Toby Terpstra, and they created this 3D visualization that you saw. And what's important about Mr. Wright's testimony is that it's consistent with what Susan Lorincz told detectives. "I was standing back near the table. There's no evidence that she moved the shell casing or did anything like that." It's consistent with what she told them. Miss Lorincz told them, "I wasn't going anywhere near that door. I was terrified it was going to come down." And he told us, it's pretty likely that Susan was standing by her table when she fired the gun. So how do we decide whether somebody is justified in using deadly force? And this paragraph sort of guides us in that, and it tells us that you must consider the circumstances at the time the force was used, all of it. The fact that she's in her home, she's alone, it's nighttime, her knowledge of Adjoka Owens and her past interactions with her, the noise level with the pounding and the screaming of the profanities, the problems that Susan Lorincz was having physically, all of it. You have to take into account those circumstances. It's what she would reasonably do. The beauty of the law is that it does not punish individuals that reasonably perceive that danger. Now let's talk more about that danger, because the law goes one step further and it tells us that the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. And we know that it was real to her because we heard her in her statements to detectives. I really thought I heard that crack and she was coming through that door. She just believed that. And if she believes that and she perceives a danger and that danger is reasonable in her shoes, she can defend herself. She does not have to wait. So was it reasonable for Susan Lorincz to think that she was in a dangerous situation where she could be hurt or killed? This is what was standing between Susan Lorincz and Adjoka Owens on June 2nd of 2023. Adjoka Owens was a 35-year-old woman who was 5'7", weighed 293 pounds, and was very, very angry at Susan Lorincz. A door frame that was broken and barely hanging on. Now we heard from Charles Gabbard. He told us, you know, I tried to fix this door as best as I could. I put some screws in it, put some putty in it, and it was structurally sound. He made a point to let everybody know it was structurally sound. Not really sure how he knows that. He didn't really do any testing. But he wants everybody to know, this is not my fault. As a landlord, that door was structurally sound. But it doesn't really matter whether it was or it wasn't. What matters is that Susan Lorincz knew the shape of the door and what it was like on that day. And she believed that door wasn't going to hold up. And was it reasonable for her to think that? Absolutely. All we have to do is look at the photos. The crack goes all the way down the frame. Almost all the way down. Was it reasonable for Susan Lorincz to hear a crack when Adjoka Owens was banging so hard on that door? Absolutely. Miss Owens was a woman who ignored not one, see the no trespassing sign in the window, not two, but three no trespassing signs. 3. And we know this was not the first time that Adjoka Owens had trespassed on Susan Lorinc's property, and we'll get to that a little bit later on. Miss Owens was very, very angry. How do we know that? What evidence tells us that? We know that there was an interaction that Susan Lorincz had with Adjoka's sons, Israel and Isaac. Susan talked a little bit about it in her statements to detectives. There was an issue with a tablet and a pair of skates and an umbrella. And Miss Owens went over to confront Susan Lorincz about it, and we heard from Yaro Rodriguez, and he took the stand and he told us, Miss Owens was mad. Yaro Rodriguez told us Miss Owens' tone was a loud and a mad one. He told us Miss Owens was screaming and using words like bitch and fuck. And he told us At first, he didn't admit it. He was like, I didn't see her knock on that sliding glass door first. But we reminded him, you gave us a deposition and you told us about these things. And he said, yes, actually, I did remember. I did see that. So she went straight to this sliding glass door and she started pounding as hard as she could. And we heard from Jareth Gardner. And he told us that he was over by the basketball hoops, and when Isaac and Israel came up to him and told him something that had happened at Susan's house, and he told us one of the kids said, "Go get AJ." He didn't really want to tell us, but he admitted, yeah, she seemed frustrated, Miss Owens seemed frustrated, and that he heard Miss Owens knocking, and then knocked again, but this time it was louder. He told us that he heard Miss Owens say, "Bitch, open the door." And he told us that Miss Owens' demeanor was like somebody had just messed with her kids. And he told us that even he started walking over to Susan Lawrence's home because he felt the energy and he knew an altercation was about to happen. This was not a woman that was coming over to have a nice chat with Susan Lawrence about what had happened with her children. We cannot ignore the realities of what happened that night. The state may compare this to someone just coming on to the little, "Come on, Susan, I want to talk to you about what happened with my kids." That is just not what happened. Miss Owens was screaming so loudly that Rosalie Smith, a neighbor that lives a football field away, heard her. She said it was so loud. So if you can imagine how loud it was for Rosalie Smith, who was a football field away, imagine what that felt like for Susan Lawrence, who was right on the other side of that door, with that broken door frame. Miss Smith told us it wasn't just 3 bangs and then another 3 bangs. She told us it was a lot of pounding. I mean a lot. And that it felt like even to her it went on forever. Yariel Rodriguez told us Miss Owens was banging on the door hard, and she was banging with her fist. I mean, he told us this is what I saw, and that she was banging in the middle of the door. And we heard from a really important witness, Yvonne Costa. The state called her as a witness, and that's Susan's neighbor that shares that wall with her. And she told us that all of a sudden she heard a banging that was really, really bad. I mean, so bad even her walls were shaking. So bad that she was scared. So it's not just Susan Lawrence saying, "Man, that banging was so loud, I was scared." Her neighbor says, "I was terrified." That's how hard it was. She told us that the banging stopped, and then she heard it again, and then at this time it was even worse. And that there was a lot of it. A lot of banging. Not just 1, 2, 3, 1, 2, 3, a lot. She told us that while she heard the banging, she heard voices. Loud, aggressive, very guttural and deep voices, and that it sounded like it was coming from outside. Miss Owens was angry. And if she got through that door, and Susan Lawrence thought that she was going to because she saw it moving in and she heard that crack, she was in fear for her life. Adjika Owens was trespassing on Susan Lawrence's property. And Susan Lawrence was in her home where she had a right to be, and she had no duty to retreat. she had a right to stand her ground and defend herself because she was reasonably afraid. Now, the state may say, well, Susan Lorinc's fear, that wasn't reasonable because Adjika Owens never got through that door. She didn't go over to Susan Lorinc's house to harm her that night. She just merely wanted to go onto her porch and talk to her. They may say, well, did she trespass? Maybe. But she never intended to harm her. But the law on self-defense accounts for situations just like this. Situations where someone unlawfully and forcefully comes onto someone else's property. The law tells us, hey, there are certain circumstances where if certain things happen, you can presume that someone has a reasonable fear. If certain things happen, you can presume that the person was going over there to cause harm. And these next two slides, they deal with that portion of the law. And we sort of have to read these in conjunction with each other, and so I want to go over the definition of dwelling. And this is something that Mr. Buxman didn't talk about, and this is really important. So dwelling means a building or conveyance of any kind, including any attached porch. Whether the building or conveyance is temporary or permanent, or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. So remember that includes any attached porch. So when we go back and we're looking at this, the person against whom the defensive force was used, aka Miss Owens, was in the process of unlawfully and forcefully entering, or had unlawfully and forcibly entered, a dwelling. So a dwelling includes an attached porch. So did Miss Owens unlawfully and forcefully step onto that porch? Absolutely. Not the door. We don't have to wait for her to get inside the actual house. The patio is part of the house. The law tells us that. So did she unlawfully go there? Absolutely, she was trespassing. Did she forcefully go onto the porch? Absolutely. How do we know that? Yariel Rodriguez, Jareth Gardner, Rosalie Smith, Yvonne Costa. She's yelling. She's angry. She's loud. She's banging. That's forcefully. That's what makes this different from someone like an Amazon driver coming to deliver a package. Miss Owens forcefully went on that attached porch, and that's the dwelling. And if that's the case, we have to presume that Susan Lorincz had a reasonable fear, because the law tells us that we have to. If that's the case, we have to presume that Miss Owens was going over there with the intent to commit an unlawful act. We have to presume that. We don't get to guess that. Well, maybe she wasn't going over there, she was just trespassing. No. The law says if she unlawfully and forcefully entered that attached porch, we have to presume she was going over there with the intent to do harm to Susan Lorincz. This slide is really important. If you find that Susan Lorincz, who because of prior threats or difficulties with Adjika Owens had reasonable grounds to believe that she was in danger or death or great bodily harm at the hands of Adjika Owens, you may consider this fact in determining whether the actions of Susan Lorincz were those of a reasonable person. So let's talk about those prior incidents that we heard about. So Deputy Coleman testified. The state called him as a witness, and he told us, yeah, I went out there in February of 2022. And he told us, Susan Lorincz told me that Adjika Owens had battered her with the trespassing sign, hit her in the leg. And Deputy Coleman spoke to Adjika Owens. And he told us that Miss Owens told him My dog likes to defecate on Susan's property. That's his favorite spot, and I don't care. That's where he's going to go. And unless she can show me a deed or something other than that, that's where he's going to go. Deputy Coleman talked to Miss Owens about this interaction that she had with Susan Lorincz. And Miss Owens again told the deputy, yeah, I told her I don't care about your sign. I can go get myself a sign if I want. I don't care about it. And she admitted to Deputy Coleman, yeah, I threw the sign. Deputy Coleman told Miss Owens, look, even though she's renting, that is not public space. That is private property. You cannot go over there. If you have an issue, call us. Coleman told us that he saw a red mark on Susan's leg, but despite that, he never arrested Adjourns Owens. But we heard from London Remy, though, right? She was there and she saw this. She told us, I saw the sign hit Susan's leg. I mean, it barely hit her, but it hit her. For whatever reason, deputies decided not to arrest Adjourns Owens. Deputy Coleman told us that Susan Lorincz had taken a photograph of Adjourns Owens when they were having this confrontation. And this was entered into evidence, and it was stipulated too that this is the photo that Susan Lorincz took of Adjourns Owens on February of 2022. Now, we also heard from Shelby Kinsey, and she was another deputy that had responded out in December of 2022 because of another altercation between Adjourns Owens and Susan Lorincz. And Deputy Kinsey told us, I spoke to both Susan, I spoke to a mother, didn't even get her name, but spoke to a mother. We later learned it was Miss Owens, and Miss Owens told Deputy Kinsey, yeah, my 9-year-old son was mouthing off to Susan Lorincz. Miss Lorincz had told Deputy Kinsey that Miss Owens came to her house, knocked on her door, and said, if you treat my son like this again, I'm going to rip your ass out of your house and beat you up. Again, on that night, Miss Lorincz told Miss Owens, you are trespassing. Please leave my property. But Miss Owens didn't leave again on that night. She said, I have my son here, and I'm just going to talk to you about what happened. Susan Lorincz said, get off of my property. And when she felt threatened, she called the police, and that's when Adjourns Owens left. Deputy Kinsey told us that Miss Owens herself said, Susan told me I was trespassing. Leave. I didn't leave. I wanted to talk to her about what happened with her and my son. Deputy Kinsey told us that Miss Owens herself told her, I said to Susan, if you walk up on my sons again, you're going to have to deal with me. Those were Miss Owens' own words. Once again, Miss Owens wasn't arrested, and Deputy Kinsey told her, you can't go over there. If you have an issue, call us. In her statement, Susan had told detectives about another time that Miss Owens had followed her a couple months before this incident, where she was like a foot behind her and she was following her almost all the way into her house. And that's the reason why Susan Lorincz had all these no trespassing signs up, members of the jury. She just didn't want people on her property. Now, this slide and this part of the jury instruction sort of deals with that same premise of if there's prior interactions between Miss Lorincz and Miss Owens. And this talks about if you find at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Adjourns Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed it was necessary for her to use deadly force. Now, Mr. Buxman said, well, threw the sign, hit Susan Lorincz in the leg. London Remy told us that it did, but who cares? It was a flimsy little sign, no big deal. Maybe it's not a big deal to him, but it could be a big deal to Susan Lorincz as she's experiencing a traumatic situation, and it's something you have to take into account, and she knew that she had been previously battered by this woman. It was a big deal to her, to Susan, and that's what matters. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Susan Lorincz and Adjourns Owens. Why does the law do that? Because it recognizes that a 35-year-old, 293-pound woman is much more dangerous if she gets her hands on a 58-year-old woman with the physical problems that Susan Lorincz had on June 2nd of 2023. Adjourns Owens has much more capabilities, and Ms. Lawrence's medical records are in evidence, and you can take your time when you're deliberating and you can go through them and look at all of those things. And we heard Susan talk about all of the medical conditions that she was suffering from when she spoke to detectives about her cervical fusion and her bad knees, her knee going backward, and all of those things. The law says you have to take those things into consideration. I want to play this visualization for you one more time, but as you're watching it and as it transitions into the part where Susan Lorincz is in her home before she fires, I want you to focus on the door. Now, the state asked, I believe it was Mr. Smith, they asked Toby Terpstra, you took some liberties with making this video. That video was created based on Susan Lawrence's statement to detectives where she told them multiple times, I saw that door coming in. I saw that door moving. She says that multiple times throughout her statement. That is what she said. So you can imagine how she sees this door moving the way that it is, and she knows that the door frame is damaged. How scary that must have been for her. And she had a split second to make a decision whether or not to fire her weapon. The state asked some of the witnesses about Susan Lawrence's demeanor after the fact. Made a pretty big deal about, she asked about her cats. They asked another witness, how did she seem? She's like, well, I mean, I don't know. Is it really that unreasonable for someone as a pet owner who has two cats to just say, hey, can you just close my door so that my cats don't run out? Because she asked that question, that must mean she wasn't in fear. And I want to address this, this is my only chance to speak with you, and Mr. Buxman may get up and speak, or he will get up and speak after me, so I want to address this just in case. In her interview, Susan Lorincz, they ask her questions about her researching Stand Your Ground. On that second interview from June 6th of 2023. But if we go back and we remember, during that June 3rd of 2023 interview, the detective says to her, the law says it has to be imminent. And he's explaining to her sort of the law, and she's like, okay. Is it reasonable for someone to leave that interview and go and research? Like, man, I wonder what the law really says about this. Is that reasonable? Absolutely. The state argues that Ms. Lorincz knew that law enforcement was on the way, but we know it took law enforcement almost 15 minutes to get there. 8:54 is when she called 911. First officer didn't respond on scene until I believe it was 9:08. A lot can happen in 15 minutes, members of the jury, when you are in fear for your life. A lot. One of the last times the police came out, when Susan Lorincz told them that she had been battered, they didn't even ask Adjourns Owens her name. The state says it's only 2.5 minutes. Only 2.5 minutes have went by. But Dr. Bedard, he talked to us about that perception and how that can feel like a very, very long time. And the state introduced some videos that Susan Lorincz had taken earlier in the day, and they had introduced this umbrella, and they introduced these skates. Even Mr. Buxman in his closing admitted, like, none of that even really matters. But they took the time, they introduced those things. Why do they do that? Do these skates, the umbrella, these videos, prove to you in any way that Susan Lorincz wasn't reasonably afraid? Because remember, they have the burden to prove she wasn't acting in self-defense. During the trial, Mr. Smith made it a point to ask some of the witnesses, particularly our expert, Joshua Wright, did you see there could have been gunshot residue on the door? All the stuff about the gunshot residue. Did their crime scene tech ever test the door for gunshot residue? Did you ever hear any of that? It took law enforcement over 2 weeks to even go out and collect that door and place it into evidence. And by that time, Charles Gabbard had already got his hands on it, sanded it down, filled it in, painted it over, before they even collected the door and placed it into evidence. A door that they made it a point to ask the witnesses, was there any dents, any scratches on it? Waited 2 weeks after Charles Gabbard had done work to it to even collect it. So I want to talk to you just a little bit, and I'm almost finished, about the state's burden. And I want to show you a little bit about sort of how that means, or what that means. If you are anywhere along this chart, other than the red part at the bottom, you have to find Susan Lorincz not guilty. If you think it was self-defense beyond a reasonable doubt, she's not guilty. If you think, man, this might be self-defense, that's not guilty. Even if you think it probably wasn't self-defense, that's not enough. She's not guilty. It's not until you get down here where they've proven to you beyond a reasonable doubt that it was not self-defense. That is the only way that you can find her guilty, because the law says so. Now this is the verdict form, and this is what you're going to see when you go back there to deliberate. And based on all of the facts and evidence, when you get back there and you're deliberating, we're going to ask you to check that box B. The defendant is not guilty. Thank you.
Mr. Buxton, can you and Ms. Sizemore approach real quick? Take a very short break, then Mr. Buxman will have his concluding statements to you. Then we'll go from there, okay? Very short break, and then we'll have some concluding arguments by Mr. Buxman. Then I will give the jury the rest of the jury instructions, probably 10 minutes or less on that. Then they'll deliberate, okay? I do want to express my thanks to all of you for how you've acted during this trial. It's been wonderful. Everyone has acted completely appropriately, and I really appreciate that. But I want to let you know something that I used to tell people all the time, is that everyone wants their side of the case to win. Everyone does that in a trial. But only one side can win a trial. And that's just the nature of things. Please, whatever the verdict is, whenever it comes back, remember that this is a courtroom. Everyone just remain silent. Ms. Lorincz, you'll remain silent. Everyone in the audience will remain silent. We'll have a few more things to do with the jurors, and then they'll be excused. Then, as far as you're in this courtroom, everyone don't say a word. Please don't express any, depending on whatever side of this you're on, no joy, no anger, no clapping, no nothing, okay? This is a courtroom. You're free to do whatever you guys want outside the courtroom. But in the courtroom, you're not free to do whatever you want. Everyone's got to keep the same perfect behavior we've had already. Again, I really appreciate that. I know that you can keep it up for the very short time we have left. We'll take about 10 minutes, and then we will finish everything up, and the jurors will do their deliberations, okay? Thank you very much. cold here today. You doing a second one, or you doing both? Okay. You guys don't remember the day when the state sometimes was in the middle,
I do.
and then the fence got there.
I'm not old.
Like when you were in county court, you didn't know what was going to happen until you had to like plan both ways. So, which really just meant splitting your one closing in two and doing it that way. But let's go back on the record. I see Miss Lorincz is back in the courtroom. And are we ready for the jurors, everybody?
Yes, sir.
Okay. When I finish reading, I will, as I usually do, ask, is there any objection to the instructions as read?
And Judge, there was a couple words that you messed up.
Okay.
So I don't really necessarily want to say that in front of the jury, so you want to just wait until they're taken out?
Tell me now, and I'll reread it.
I don't really think that it's necessary, I just didn't want to, yeah.
Which word? I mean, if you have an objection, I need to address it now, and I'll read instruction.
I have no objection.
But if you want me to is it like something?
I think you just said when there was, hold on. In the word injury, you said harm, and then you're talking about the capacity, I think you said something different.
You said capabilities.
But it doesn't matter.
Capabilities as opposed to capacities?
Yeah.
That's highly possible. Where is that in justifiable use of deadly harm?
It's at the end, for the capacities one?
For which one?
Are you asking about the capacities one?
Yeah.
Yeah, it's in justifiable use of deadly force under, when you're talking about the physical capabilities between the two.
So I said capability as opposed to capacity.
Yes, I believe so.
I can reread that if you would like me to.
You can reread it, Judge, I don't have an objection.
I mean, they have almost the same definition.
Right.
The state has no objection.
Seems like capability is more appropriate anyways, but I don't know what capacity means. But if I said capabilities, if you want me, and I may have, okay, I have no question. If you want me to reread that, I'm happy to reread it. If you don't want to reread it, let me know.
I don't think you need to reread it.
Okay, so you do not want me to reread it?
Correct.
Okay, so the two words are basically interchangeable, more or less. So if anyone wants me to reread it, I apologize for misreading a word. If anyone wants me to reread it, tell me now. If not, then I'll consider it waived. All right, so I'll consider it waived. And we'll bring it back, and I'll try to make sure I enunciate each word more clearly. The jurors have returned. Mr. Buxman, you ready to proceed? You need the screen?
Yes, sir.
You ready for it now?
Yes, sir. Thank you. I want to start by talking about a few things in the defendant's interview and the testimony of Roy Bedard, and then I want to talk a little bit about reasonableness and eminence. You heard in the defendant's interview, I think on one occasion, there may have been two occasions, in which she indicated that Miss Owens damaged her door in the past? Well, look at the evidence that we have before us. We know the first incident that happened in February of 22, Deputy Coleman came. There was no indication that the defendant reported any damage to her door, showed Deputy Coleman any damage to her door then. We heard about the incident from February of 2023, February, and Deputy Kinsey responded. There was no indication of any damage done to her door. During the interview, the defendant talked about that third incident where she went over across the street into the driveway and confronted Miss Owens about telling a neighbor that she was a crazy bitch. There was no explanation or no discussion about damage to her door at that point. You heard from Dr. Roy Bedard, and ask yourself, what did he add to this case? He's not a psychologist, he's not a psychiatrist, he is not a medical doctor. He spoke in generalities. He told you about various theories. He told you about the structure in the brain and the adrenal glands and how people make decisions and what happens in a stressful situation. His testimony boils down to the more imminent and severe a threat is to someone, and the less time a person has to assess the situation and process the data, the more error that creeps into the decision. I talked with him about the example, if I'm driving down the road, the person ahead of me slams on the brakes, I have to make a split-second decision. Do I slam the brakes? Do I swerve right? Do I swerve left? Or do I just brace? If I have a half second to react to that, the chances of me stopping or avoiding the threat is lower. If I have more time to evaluate and process the situation and assess my surroundings, the chance of me making a reasonable decision and a safe decision goes up. That's common sense. The threat, this perceived threat that the defendant indicated she had that day was not imminent. The threat, assuming you can even call somebody banging on a door and yelling a threat, was a threat that was coming from the opposite side of a closed, locked, deadbolted metal door. It was not immediate. It was not imminent. It was not about to happen. There was no threat. And the defendant didn't have a split second to make a decision. She had a period of time to make a decision. And she made a variety of decisions during that period of time. And that's kind of what I want to go over in this part of my closing. She told the detectives that she thought the door was going to break down, break in. She thought Miss Owens was going to burst through the door and kill her. We know that the defendant is prone to unreasonable degrees of fear. When she was talking in her interview about the sign throwing incident, she told the detectives, and then when the first time when she threw the things at me, she was just so horrible to me. I was like, I just had neck surgery. And I'm like, she could have really killed me. And I was just like, oh dear God, she was just violent. She is describing an incident where Miss Owens picked up a no trespassing sign, about 8 by 10, with 2 little prongs that go into the ground, and tossed it at her as she was walking away. Is that reasonable to believe that that act could have reasonably killed the defendant? Of course not. And again, London Remy showed you how it happened, showed you that she tossed it. But she tells the detectives that she's like, Miss Owens could have really killed me. That tells you the reasonableness of her fear. And remember, we're looking at reasonableness through the eyes of an average, ordinary, everyday person. You heard about, and we talked about the incident, the second incident that Deputy Kinsey responded to. And Deputy Kinsey told you that she walked up and talked to the defendant. The defendant's first complaint was about the kids trespassing. And only after that does she explain or say that, oh, Miss Owens said that she was going to drag me out and whip my butt. It's interesting that she never mentions anything about that on the 911 call. She doesn't say, oh my God, I had to shoot through this door, this woman had threatened me in the past. She doesn't say that. She doesn't mention anything about that statement in either of her two interviews, despite talking to the detectives for hours. Ask yourself, how much of a role did that event play in the defendant's decision-making process to fire the gun through that locked, deadbolted metal door? Let's look more closely at the circumstances about what was going on that night and look at her own words to assess how truly afraid and how reasonable her fear was. Her first 911 call.
Yeah, the secretary's out there right now. I'm sitting for my life. I'm very scared.
It's a cell phone video from her phone taken 5 minutes before she makes the 911 call. That's what's causing her fear. That's taken moments before she calls 911. Ask yourself, is that a reasonable fear? That she's in fear for her life? That's not reasonable. So she tells the 911 operator that she is so afraid of these children, she's in fear for her life from these children. Does she run into her house, barricade her house that very moment? No. About 30 or 40 seconds before she calls 911, she's outside taking more video. But she just tells the 911 operator she was in fear of the children. Ask yourself again, is that reasonable? Her actions are completely inconsistent with somebody being in fear for her life from those children. Still the initial 911 call.
They just kept badgering me and badgering me. I'm just sick of these stupid.
Does that sound like fear of the children, or does that sound like anger?
Are you or anyone else in danger right now?
I locked my doors.
She tells the 911 operator she locks her doors, so there is no danger. Those doors were still locked. That door was still locked and deadbolted when Miss Owens comes over. Now she says she was in such fear of these children, in fear for her life, based on what she told the 911 operator. But there's a chain up there on the door as well. Does she activate that chain? She does not. She doesn't add that third level of security. Why not add that level of security if she was truly in fear for her life from these children? She doesn't do that because she wasn't afraid. She was angry. If she's in such fear of this 9-year-old child, does she take the chair that she says that she places under the doorknob and put it there for added security? No. Because again, she's not in fear of these children. She's angry. She had to walk right by that chair to go to the bathroom, like she said that she was when the pounding and things started. So we know from her interview that when this pounding and yelling began, she was in the bathroom. She hears this pounding and yelling, and she is so afraid, she goes and washes her hands. She tells you that the pounding and yelling stopped. Like it would stop if somebody is banging on the door, come out, and there's a pause for the person inside to come to the door or to react or acknowledge. Then when there is no reaction or no answer to the door, the pounding starts up again and gets louder. That is the complete opposite of somebody who is trying to get into the house. Again, there is no evidence that Ms. Owens was trying to get into the defendant's house. If she wanted to, she had every ability to do so. But she's banging, come out, pause and wait, bang again. And then the gunshot happens. If she wanted to get into the house, why not shatter the sliding glass door? Why not continually bang? Why not throw the body up against the door? None of that happened. We heard from Uriel Rodriguez who said none of that happened. She was banging. I mean, she was banging hard. State never tried to hide that, and I never tried to suggest otherwise. She was banging hard. As we talked earlier in my first closing, that the defendant she's not required legally to retreat because she is in her own home. So in order for her to claim and argue self-defense, she doesn't first have to retreat. But her actions inside the house are relevant to consider the degree of fear, the reasonableness of her actions, and the imminence of this perceived threat. So what do we know? When the banging and yelling starts, she's in the bathroom. This is based on her own words in her interviews. She doesn't shut and lock her bathroom door to put up another barrier between herself and this perceived threat. Instead, she leaves the confines of that additional safe space and walks towards the kitchen, towards the door. Does that sound like someone who is afraid for her life? Of course she's not, because there's a big metal locked deadbolt door standing between her and the knocker and the yeller. In her interview, she admitted that the first words out of Miss Owens' mouth were, "Why do you speak to my children this way?" Not, "I'm going to kill you." I'm going to come into your house. So why do you speak to the children this way? When the yelling starts, she doesn't go find her phone that she had 2 minutes earlier when she just hung up the phone with 911 to call again. Instead, she goes to the bathroom to wash her hands. Ask yourself, how truly, reasonably terrified is she? The banging starts up again and she goes to her bedroom. She grabs the gun from her bedroom, and she doesn't grab the .22, the Ruger, the little plinker that she called it. She grabs the more powerful .380 Remington firearm. She doesn't shut and lock her bedroom door where she is with the gun to put up another barrier between her and this perceived threat in case by some chance, if she truly believes that Ms. Owens is going to come into her house, now she has another barrier to protect her. She doesn't do that. She doesn't walk around the corner and point the gun ready and waiting. No, she doesn't do that. Instead, she leaves the additional safety and security and that additional barrier that she could have put up and walks towards the door. Walks towards this perceived life-threatening threat. She says she walks up to the kitchen table, she raises her firearm, points it at center of mass, where a person would be, and pulls the trigger. One shot. Not a panic flurry of gunfire, one controlled, precise shot, a kill shot. Ms. Sizemore told you that the defendant, there's evidence that at the time, right before she shot, the defendant said that she heard a crack in the door. You will listen to both interviews and the 911 call. You looked at the transcripts. If you want to listen to them again, you have every right as a jury to listen to those interviews again. Nowhere in those interviews does she say anything such as, "I heard the door breaking, I heard the door cracking before I fired." If you want to listen to them again, you have every right to do so. There is no wood splinters on the floor. There's no new damage to the door frame. There's no wood hanging off when the deputies get there and the crime scene investigators examine it. There's no evidence whatsoever to indicate that there was a crack before the gunshot took place. You heard from Josh Wright and Toby Terpstra. They collectively created the diagram as well as the digital animation. And using the diagram created by the defense, before we do that, Catherine Medina, there was discussion about Catherine Medina doing the trajectory analysis and how that she didn't calibrate certain things. Her role was not to do a full-blown trajectory analysis. She's told you she doesn't have the training and the experience to do that. Her goal was to create a general representation of the trajectory. And even Josh Wright said, based on what she did, it may be a little larger cone of error, but her job and what she did and her representation was a good representation of where the defendant would have been in the path of the travel of the trajectory of the bullet. But take the diagram provided by the defense as true. Who fires a gun like this? She's trained, she's gone to the range, she's practiced. I think in her interview, she said she's watched videos of how to properly shoot and things like that. She even demonstrated in her interview that she held the gun like normal people hold the gun. People don't hold the gun over your head like that. That's the representation provided by the defense. That is inaccurate. That's not reasonable. People don't do that. In order for the gun to be brought down lower, she has to advance closer and closer to the door to maintain that trajectory line. Now, ultimately, does it really make much of a difference where the defendant is standing in her house when she fires? Not really. Does it matter if she's standing right by the kitchen table or if she's standing a foot or two up or a foot or two back? Not really. It doesn't change the facts in this case. What's important about where she's standing is, assuming she's even standing where she says she was standing, what's important is after she gets the gun, she's approaching the door. She's walking towards whatever this life-threatening threat that she thinks there is. She's approaching that threat. That is inconsistent with somebody who is afraid for their life. That's, unless you're a law enforcement officer, or military, or firefighter, most people don't approach the threat. They don't run toward the threat. You heard and saw the video reenactment created by Mr. Terpstra. He admitted that that was based on the defendant's version of events. The video and the way he went about creating it, it was pretty cool. It was neat. But ask yourself, what does it add to this case? It shows Miss Owens banging on the sliding glass door. Well, we know that happened. Gabriel Rodriguez told you that. It shows the defendant, or Miss Owens banging on the outside of the defendant's door. Well, we know that happened too. It showed the defendant walking towards the door with her gun raised and firing a shot through the door. We know that happened. And it showed the shooting of the projectile, the bullet, through that closed door and hitting Miss Owens. We know that happened. Now, he took some artistic liberties by making the mirror shake and the door shake, and he did that on his own. He's basing it on the defendant's interview, but he decided how to make that happen and how to artistically represent that, to represent the degree of force that the defendant said she saw. That's not evidence. That's a representation of his artistic representation of what he thinks the defendant meant and what the defendant said she saw. Again, the video was cool, but it really doesn't add anything to this case. So after the shooting, we hear she makes the second 911 call. And we heard during the first couple minutes of that second 911 call, she's crying. She's upset. Of course she's crying and upset, ladies and gentlemen. She just fired a shot. She knows she shot somebody and realized the gravity and the implications of what her decision was. But notice how her demeanor changes very quickly during that 911 call when she starts talking about the children.
Something keeps trespassing over here. They're bothering me and bothering me. They won't fucking stop. See, her boys were here earlier. They keep leaving their garbage all around the house. Okay. And then I told them to take the crap away. Get the fuck out of here.
That's after she fires and after the first initial minute or two of her crying. She's still angry on the 911 call. You saw Deputy Barbosa's body-worn camera when they had first made contact with the defendant. That happened right after she hung up with 911. She wasn't hysterical. She wasn't bawling her eyes out. She was calm. She was cool. She was collected. I think she asked to go in and get water and asked for something to be done with the cats. And look at her demeanor within minutes of being placed in the patrol car. She's, again, not crying. She's not hysterical. This goes to the reasonableness of her fear. Deputy Welfenberg described her demeanor as indifferent. As I said earlier, ladies and gentlemen, the law requires the threat of death or great bodily harm to be imminent before deadly force is used. There was no imminence at the time she fired that gun. The word imminent is very important. It's included in the law and in the instructions for a very important reason. In order for the defendant to lawfully use deadly force, the threat to her life had to be imminent, had to be ready to happen, had to be staring her in the face such that she had to act at that moment to protect herself. Now, some of the defendant's medical records were introduced, and there's no dispute that she has those medical records and she has some medical conditions. And if this was a situation where Miss Owens broke down the door or broke that sliding glass door and was coming at the defendant, those medical records might be relevant because her physical ability to actually engage in a fight could be relevant to this case. None of that happened. Why? Because there was a big door standing between the two of them that couldn't be breached. The defendant knows what imminent means. You heard in And then she had the presence of mind to go back with the gun she just used to shoot and put it back in the trash can underneath the smaller .22 Ruger. Ladies and gentlemen, as a society, we do not condone shooting another person because of an act that may occur in the future, or because X, Y, and Z may happen, and I may be forced to defend myself. Law enforcement officers are not allowed to go around shooting people because the person may have a gun, may pull it out, may threaten the officer with it.
Objection, number of argument.
That's sustained.
The danger has to be imminent. Not, it could happen. It may happen. If 2 or 3 or 4 things occur, it may happen. That's not imminent. The defendant does not get to shoot Miss Owens because Miss Owens may somehow manage to get through that door and may then decide to attack. Because before that door is actually broken in, Miss Owens has no physical ability to cause any harm whatsoever. That is the law that we have agreed to live by. Because there was no imminent danger when the defendant pulled the trigger, her decision to shoot and kill Miss Owens was not reasonable, and it was unlawful. We talked in jury selection that your role in this case is to determine whether or not the defendant's actions on the night of June 2nd, 2023 violated the law. It is not anyone's role here to determine if the defendant is a good or a bad person. And this decision that you're about to make should not be based on sympathy to Ms. Owens, her family, sympathy to the defendant. Your decision in this case should be based on the law as the judge reads it to you and how the facts that you know that have been proven apply to that law. And as I said when I started this, the facts really aren't in dispute. Ms. Owens is banging on the door yelling. She's angry. She's angry about how the defendant treated her children. Ms. Owens is not trying to jiggle the doorknob or break down the sliding glass door, break the window, not trying to get into the house in any way. Law enforcement was on their way. She gets her gun. She fires one shot, center of mass, which kills Ms. Owens. The judge will tell you that it's your duty to determine if the defendant is guilty of manslaughter. If you find the defendant guilty, it is his job to determine what the proper punishment or sentence should be, not yours. I submit to you that if you are back in the deliberation room talking about the case and you're thinking, what's going to happen if she is found guilty? You've already made your decision that she is guilty, because that's what the evidence has proven. After you boil down the facts and circumstances, you really have to answer one question, like I said when I started. Following the laws that we have agreed upon, is it okay to shoot through that closed, locked, deadbolted metal door as someone who was banging on it and yelling, but posing no imminent threat? Based on the facts of this case, it's not okay. Based on the law in this case, it's not okay. Just being afraid is not enough. Just her saying she's afraid is not enough. Using that ordinary, average, everyday person standard, you have to ask yourself, were her actions reasonable? Was her decision reasonable? And was that threat imminent? Was it about to happen right now? Ladies and gentlemen, the facts of this case have proven her decision was not reasonable. The decision wasn't made while acting in necessary self-defense. It was not justified. Because of that decision, because of that unlawful decision, Lachika Owens lost her life. We ask you find the defendant guilty of manslaughter with a firearm, because that's what the evidence has proven beyond any reasonable doubt, and that's what the law requires. Thank you.
Ladies and gentlemen, if you listen carefully, have your final instructions, okay? Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You have heard testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1. Whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2. Whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision in this matter. 2. The case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. Here, there is only one crime, so only one verdict may be returned. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It reads as follows. It says right on it, verdict. Count 1, the only count. We, the jury, find as follows as to count 1 of the charge. In parentheses, check only 1 as to this court count. The first choice, A. The defendant is guilty of manslaughter. If you check A, you must then answer the following question. Did the state prove beyond a reasonable doubt that, during the commission of the offense, the defendant personally used a firearm? You'll check either yes or no. The other choice, B. The defendant is not guilty. So say we all, dated, this is the 16th day of August, 2024. This will need to be signed in pen by the foreperson, and the bailiff will have a pen back there for the foreperson to use. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way, and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions, or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. This includes any sort of like Apple Watch or anything else where you can get and send emails or make phone calls, okay? You'll need to leave that with the bailiff. If you have an old-fashioned watch like me, you're fine. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items are received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. A, these exhibits will be sent to the jury room with you when you begin to deliberate. B, if you wish to see any audio or video exhibits, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you don't like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Give me 1 second. Put my stuff together here. At this point, in just a few moments, you're going to go back to the jury room, okay? We'll have your lunch for you shortly. You can either eat lunch and then deliberate, or deliberate through lunch. Choice is yours, okay? The evidence, the physical pieces of evidence that you can physically see and touch and look at, they'll be brought into the jury room for you. Electronic evidence, 911 calls, the recordings of the conversations and the statements, anything that you saw digitally on the screens, you'll need to request to come back out here to watch that, because obviously we have no computers in there for you to watch it. But send me a note, and then we'll bring you out here all together, and we'll all watch it. You can watch it as many times as you want. You can get as close to the screens as you want. The choice is yours, okay? There's no limit on your deliberations. You can take as long or as short as you need to decide this case. The final instructions that I just read, these instructions are for the foreperson. I have put the verdict form on the back of the instructions so it's easy to find. The other 5 copies are for the other 5 jurors. They don't have a verdict form, okay? The reason I said 5 is because 2 of you have been serving as alternates, and the alternates will not go back into deliberation. What's going to happen is you'll still get your lunch, but we'll have you take that in another room, and then I'll discharge you after that, okay? The alternate jurors are, and remember your numbers, juror number 7 and juror number 8. If you're our juror number 7 or number 8, I'm going to ask you, do you have anything left in the jury room? If so, please retrieve it at this time and bring it out here. The rest of you are not alternates. So as soon as they come out, I'll let you go back, okay? And give the bailiffs a few minutes. They'll bring in all the evidence for you. And they'll also bring in the instructions for you. Yeah. If you all would just wait there, the rest of the jurors, you'll go back to deliberate, okay? And we have the instruction for you. what I'm going to do is we'll have your lunch for you in the other room, and then when you're done with your lunch, we'll take care of you being discharged, okay? I'm going to ask you, even though you go home, not to look up anything about this case or discuss anything about this case until the end of the night, okay? Or if you hear the case is over. The reason for that is if something happens to one of these jurors, you could be brought back in to participate in deliberations. So I need to keep you as pristine as you are now, okay? So we'll take jurors number 7, number 8 to the other jury room, give them a lunch, and then you'll be discharged with my thanks. And I do appreciate it. Have a very pleasant day. The jurors have retired from the courtroom. Is there any objection to the instructions that I read?
No.
Did I mess up any words?
No, sir.
There was one error in there about the other trust. It's always one. But we're down to maybe one, so that's maybe progress. All right, so we'll be in recess until we hear something. Thank you all. All right, let's go back on the record on Ms. Lorincz. I see Ms. Lorincz is here. The parties are here. The question, it says from juror number 2, can we listen to both 9/11 calls? Any objection to that by anybody?
No, Your Honor.
All right. And if I don't know if I believe I asked, but there was no objection to the instructions that I read. Is that correct? No one objecting to the instructions
Correct.
as read?
No objection.
Yeah, actually, I think I mentioned it, but I can't remember. Let's bring it back in. Can we get that queued up or?
It's ready. I'll make sure the volume is working correctly.
Mark, this is question number 1. For you can also only part of the paper. So some people use the whole paper for just a simple question. Welcome back, ladies and gentlemen. It's my understanding you have presented us with a question. I'm going to read the question into the record. The question is, can we listen to both 9/11 calls? And the answer is yes, and we'll play them for you now. Again, as I told you before, you can listen to them as many times as you want. If you need a volume up or down, let me know. And we'll play them for you in just a minute, and then we'll go from there, okay? If you want to listen to them again, you can always do that. We're playing them in the first one first.
911, what is the address emergency?
1662 Southwest 107th Lane.
All right, and then can you repeat that for me one more time to make sure I have it correct?
1662 Southwest 107th Lane.
All right, and what is your phone number in case you get disconnected?
352-777-5919.
What is your name? I'm sorry, you said your name was Susan?
Yes,
And what was your last name, Susan?
Lorincz, L-O-R-I-N-C-Z.
All right, and tell me exactly what happened.
I got kids trespassing down there, leaving all the toys around. It's just screaming, just being absolutely obnoxious. I went into the roller skate over to the other side. The kids said I'm going to beat you up for that. And he's mouthing off to me.
All right.
Threatened in my own head.
All right, is he out there right now?
Yeah, there are several kids out there right now. I'm feeling for my head. I'm very scared.
Okay. Alright, and what unit number are you in?
3.
Unit 3, okay.
Yes.
Do they also live in the same building?
No, they live across the street.
Okay. Was there any weapons involved?
And then,
How many people are involved?
earlier there was about 20 kids out here swimming around. After the room, there was 2 years, now there's 2 boys.
3?
Yes.
Okay.
You can use your discretion and get there without a call. But recognize if you got
And the kid saying I took his iPad and all this other shit was just in his food. The only thing I was looking was up all his food, and I don't want to get hanging with these children.
Alright, and are they white, black, Hispanic, or Asian?
I think one is Hispanic, the other 2 are black.
Alright, and then the Hispanic, how old would you say he is?
That's wrong.
12, alright. Were they all about the same age?
They're both.
Alright, and then the Hispanic male, what is he wearing?
He's got, I think, a t-shirt and pants on.
Do you know what color t-shirt?
No, I couldn't tell him that.
Okay.
I just don't like them coming around my house. They've been coming onto my deck, my patio, and it's telling me, get up, get up. And I'm watching TV and stuff. They have no business over here. There's no trespassing signs. I don't like the kids threatening me that they're going to beat me up, that they're going to get someone else to kill me. This is just ridiculous.
Are you or anyone else in danger right now?
I locked my doors.
Alright, who is in charge of the property?
Charles Gabbard.
I'm sorry?
Charles Gabbard owns the actual club.
Alright, but are you on the lease?
Oh yeah, I'm just at least the 1 unit. They just keep badgering me and badgering me. I'm just sick of these stupid. Now that they're home from school, it's like, craziness.
Alright, do you want you to avoid that person and then keep your doors and windows locked? An officer will be dispatched as soon as possible. Do you want the officer to contact you?
Please, yes.
Alright.
Because what's going to happen is mom's going to go out, wait for the officer on one and say, oh my God, I was threatened with kids. Which just isn't true.
Alright, and then I'm going to go ahead and let you go, but please call us back if anything changes or if you get any further information or if they do leave, okay?
Okay, thanks.
Thank you. Alright, bye-bye.
Bye.
Does anyone want to hear that call again? Does anyone want to hear that call again? Okay, we'll move on to the next call.
911 is the address of the emergency.
1662 Southwest 177. Oh my God, this lady just tried to break down my door. I'm shot through the door.
Okay, repeat that address for me to make sure I have it correct.
1662 Southwest 177.
Okay, what is your name? Okay, what's going? Take a deep breath for me. Calm down.
Oh my God.
You said someone tried to break down your door. Is that correct?
Yes, the woman was screaming and yelling. She was trying to break down my door. And she was...
Okay, it was a female.
Yes. I didn't know what to do. I grabbed my gun and then shot at the door. Oh my God.
Okay, you said you shot at the door. Is that correct?
Yes, I shot at the door because she wouldn't stop. I thought he was going to why she wouldn't just decided to say it.
Okay, where's your gun now?
It's in my bedroom. I didn't know the door was anything. Because the woman who attacked me.
Okay, do you still see the subject?
I don't know where she is. I'm still in my house. I didn't open my door to her.
Is just only you in the home?
Yes, it's just me.
Okay, I just need you to lock all your doors and windows, okay?
I have.
Okay, I'm gonna stay on the line until the deputies get there.
Okay. Something going to come and kill me.
And did you know her?
She's come after me several times because of her children. Her children keep trespassing over here. They're bothering me and bothering me. They won't fucking stop.
Is she a neighbor?
Yes.
Do you know where she lives?
She lives at 1663 Southwest 107th Lane.
163 Southwest 107th Lane, is that correct?
Yes.
Okay. Do you know her name?
H.I. Owens.
I'm sorry, what was the first name?
H.I.A.J.I.K.E.
Okay. Just let me know when you see the deputies, and like you said your gun is put up in the bedroom. Is that correct?
Yes. Okay. Jesus Christ.
And what unit number is for the subject?
I don't know. I don't know if she's one or two.
Okay.
She's an old broken down Honda or something, a white car in front of her house. It's all garbage.
You said a white Honda?
Yes. And then she has a new Acura.
Okay. You're doing good. Just take a deep breath for me. You do have deputies on the way, okay?
Okay.
And do you see the male subject, or you just see the female?
See, the boys were here earlier. They keep using their garbage all around the house.
Okay.
And then I told them to take the crap away, get the stuff out of here.
Do you know where the boyfriend is now?
I'm sorry?
Do you know where the boyfriend is now?
No.
Okay.
I'm not screaming outside now.
And we do have deputies getting close, okay?
Okay, I think they're here now. I see the way.
Okay, if they're there, I'll go ahead and let you go.
Okay, thank you.
You're welcome.
Bye-bye.
So do you want to hear the 911 call again? Okay. You're welcome to listen to it as much as you want. If you want to listen to it again, send us the same note. We'll play it for you again, either one. Okay? You return to your deliberations. Thank you very much. All All right, the jurors have retired from the courtroom. We'll wait for their communication from them. Go into recess. All right, so the jury has submitted another question. The question says, can we get clarification on when the door frame was damaged and how it was damaged and by whom? Obviously, we cannot give them information. So the question is, how do y'all want me to answer? I normally would answer, and you can add or subtract or object, whatever you want. I normally say all the evidence that's been received in this case. You'll need to make your determination based on whatever evidence has been presented in this case.
I think that's the appropriate answer, Your Honor.
So let me write that out. So
That's fine with the defense judge.
all of the evidence in this case has been presented. All of the I'm going to say we cannot answer your question. Because it's a question of fact. So I say we cannot answer your question because, or just say don't, for any reason, or just leave it at that?
I would just leave it at that.
Okay. We cannot answer your question. Trying to get that second phrasing down. I think what I'll say is you will need to make your decision based on the evidence that has been presented.
Yes.
Yes, sir.
Okay. Or admitted. So I hate to give anyone the idea that there's more evidence that they don't know. I just want to say it. So I'll say this. We cannot answer your question. You will need to make your decision based on the evidence that has been admitted.
Yes, sir.
Let's bring it back, please. Everyone's okay with my answer?
Yes,
Yes,
sir.
sir.
Okay. There you go. Oh, I need it back. I need to read it. Welcome back, ladies and gentlemen. I have a question here, and I'm going to read it into the record. Let me know if I have it wrong. Can we get clarification on when the door frame was damaged and how it was damaged and by whom? Is that the correct question? We cannot answer your question. You will need to make your decision based on the evidence that has been admitted. All right? Return to the jury room, okay? Thank you. Okay, we'll go into recess once again.
All rise. Court's now back in session.
Have a seat, everybody. All right, we're going to go back on the record on the state of Florida versus Susan Lorincz. What we're going to do is we'll bring the jurors back in. Before we take the verdict from them, I'm going to read the jurors their instructions upon discharge, which gives the jurors their rights. I hope everyone will respect that. And remind everybody to keep the same calm demeanor we've had the whole trial. Again, I appreciate it. The jurors will pass a note to the bailiff and to me. The clerk ultimately will publish the verdict. Either side wants the jurors polled. Again, we will poll them by number. Okay, and they have their numbers. Let's bring them in. Yes, ma'am. Okay, yeah. Ladies and gentlemen, it's my understanding you have reached a verdict in this case. Is that correct? What I'm going to read to you is the last instruction. This regards you as jurors. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Can you please hand the verdict to the bailiff, please? I'm going to have the clerk read the verdict.
Verdict as to count one. We, the jury, find as to count one of the charge. The defendant is guilty of manslaughter. Did the state prove beyond a reasonable doubt that during the commission of the offense, the defendant personally used a firearm? Yes. So say we all, dated the 16th day of August, 2024.
Does either side wish to poll the jurors to be polled?
Yes, sir.
Madam Clerk, please poll the jurors by number only.
Juror number 1, is this your verdict? Juror number 2, is this your verdict?
Yes.
Juror number 3, is this your verdict?
Yes.
Juror number 4, is this your verdict?
Yes.
Juror number 5, is this your verdict?
Yes.
Juror number 6, is this your verdict?
Yes.
Ladies and gentlemen of the jury, if you can go back to the jury room, please wait there and I'll discharge you in a few moments, okay? Here we go. Also, here's the last one. Oh wait, I don't think I dated that. Let me get that one back. Ms. Lawrence, the jury has found you guilty of manslaughter with a firearm. You're going to be adjudicated guilty of that offense. I assume that sentencing will be at a later date, is that correct?
That's correct, Judge.
Are you requesting a pre-sentence investigation?
Yes, sir.
What I'm going to do is have the Department of Corrections prepare a pre-sentence investigation. I'll continue this case. I'll put it all the way to the November docket, although I expect us to be sentenced long before that. I'm just putting us far enough away to get everything done. So when we get the PSI done, then please contact my office. We'll set a sentencing. Ms. Lorincz, you're going to be held in custody of the Marion County Jail without bond until that time, okay? Thank you and good luck to you.
Thank you, Judge. May we be excused?
Yes, ma'am.
Thank you.
Oh, God, thank you.
I understand. What else is, please go ahead, okay? We will be in recess. All right, course will be a recess. Thank you, everybody. Have a nice day.
You guys all good? Everybody good? Okay, thank you. I hate standing at this podium lately. Unfortunately, we're here. The good prosecutor, Karen McDonald, and I tag teaming yet again on another terrible, terrible case. So I'll give you a little bit of the background, and then our prosecutor will speak to the charges that have already been issued. So the baseline is this: on August 7th, we received information concerning potential criminal activities of a physician, Dr. Omer Ajaz. Omer Ajaz, I believe is the pronunciation. 37-year-old Rochester Hills resident who's married and is the father of 2 young boys. The allegations were that he was engaged in activity, including but not limited to placing hidden cameras in changing rooms, video recording young children as young as 2 years of age, and all the way up to grown adults in different settings. The current criminal charges, which the prosecutor will speak to, are primarily from activities conducted in Rochester and Rochester Hills when he was off duty, where he appears to utilize cameras that were deployed separate from himself and then also on his person. They were used in changing rooms, bathrooms, hospital rooms, as well as inside closets, bathrooms, and bedrooms of residents that he had access to. We believe the criminal activity has been going back at least 6 years, but this is, and I can't stress this enough, so much the tip of the iceberg. He was arrested on August 8th by our detectives as they were serving a search warrant, and again, formally charged by the prosecutor, which she'll speak to those charges. He's currently in our jail at $2 million cash bond, no 10%. So the background on this individual is he's an Indian citizen, has been working in the U.S. on a visa, came to the United States about 2011 for his internship in Michigan. He moved to Dawson, Alabama around 2018 and returned to Oakland County to continue his practice here. So this may stretch not just in Michigan, but to other states and potentially even other countries. He has worked at Ascension Genesis Hospital in Grand Blanc and Henry Ford Macomb Hospital in Clinton Township, but we're still trying to determine where else he may have worked. He was apparently an individual, a contracted physician that went 2 different locations for a company rather than having his own specific practice. So we still don't know the scope of how many facilities or venues he may have visited in that regard. It's obviously, as I said, very active investigation. It's in its infancy. We've already done a great number of search warrants. We've confiscated at this point 6 computers, 4 cellular phones, 15 external storage devices, and just one of the hard drives has 13,000 videos. So each one of them will have to be gone through to determine if there's criminality or potential criminality in those videos, and then the prosecutor ultimately will determine if there is the charges from those. This could take as long as 6 months just to get through what we already have. So our computer crimes unit is deeply engaged in this and has put tons of hours into this already. And the other potential is there also might be cloud storage. So we're trying to run that down, which obviously would add the potential for more. Due to the lengthy time that he's been involved in this activity and the large amounts of storage that we have in our possession, we believe there's obviously a lot more to be uncovered. So we're seeking to identify more victims, and we set up a special email for anybody that believes that they are a victim of this activity to email and communicate directly with our investigators. We'll be displaying that, but I will read it to you. It is OCSO, like our initials, SIU, which is our Special Investigation Unit, OCSO, SIU at oakgov.com. We'll put that up on the screen. If you believe you've been a victim or have information about this individual or this person's activities, please send us anything that you have or any questions or concerns you have. We believe he did his residency at Sinai Grace, and as I said, then went to Alabama, and has been involved in a lot of different scenarios. So, you know, as we look at this, and I've been involved in sexual predator criminal investigations for a long time. You know, I've been in law enforcement 37 years. And in my early part of my career, I did a number of investigations of sexual predators. And then in a moment in between that career, I was a senator, and I wrote the Sex Offender Registry Act. And so I went deep down the rabbit hole of profiling sexual offenders to determine how they operated and how we could best protect the public from them. This individual potentially is one of the worst I've ever seen, because there's no particular category. It's not just children. It's not just women. It's not just men. It goes from a 2-year-old to a grown woman. And so the victimization is so broad and the perversion so great that we're just beginning to wrap our arms around it. And disturbing on so many levels that it's hard to look at the videos of that activity where a woman is basically unconscious in a hospital bed and he's violating her, to a 2-year-old thinking they're out for a great swim day and they're being captured naked. There's nobody that's out of bounds for this sick activity. So I'm excited that our prosecutors already got him locked up while we continue the investigation. If there's medical facilities that I have not talked about that have had him licensed or practicing in their facility, they need to let us know, because we're working to get our arms around how big this is. But when you think about the incredible perversion and destructive activity of Nasser, he had a much smaller group of victims in terms of potential. There's no limit to his perversion of this individual. And so we're going to need the public's help and victims' help, because a lot of these we may not even be able to identify because we have so many victims, so many videos of people. We have no idea who they are and sometimes yet what the venue is. So with that, I'll kick it over. I'll put up the, that is our individual. I'll let you capture that, and then I'll put up the email address and I'll kick it over to our prosecutor.
How old is he?
37.
Thank you.
And that's the email address on the bottom.
Thank you so much, Sheriff. I'm going to talk about the charges that our office has already issued. But first I want to say, much like Sheriff Bouchard, the victims are our primary focus. I too started my career as a prosecutor, prosecuting child sexual assault cases. And, I feel like we find ourselves saying a lot, this is the worst we've seen, and yet we see worse. But this particularly hit home to me as just being a mom. These allegations stemmed from a mom bringing her young children to a swim school and taking them into a changing room and getting them changed. And the allegations are that the defendant was filming them from a nearby changing area stall. And it's a complete violation, and it's terrifying as a mother. And we're going to do everything we can to hold him accountable. And we're working in partnership with that. As the sheriff just said, this stems from events that occurred, the events of our current criminal case. August 13th, the defendant's wife produced materials that were concerning the Oakland County Sheriff's Office, immediately executed a search warrant and confiscated more devices, and has sifted through really jarring, alarming images, and they're still doing that. He is charged with 1 count of child sexually abusive activity, 4 counts of capturing an image of an unclothed person, 5 counts of using a computer to commit a crime, and he's being held on a $2 million bond, no 10%. We feel confident that he will remain there. Of course, these are all allegations, and the defendant's presumed innocent until proven guilty in a court of law. As the sheriff said, it's extremely disturbing. These videos were taken, these images, some of them in a swim school in Rochester, where moms and kids were just there for their swimming lessons and changing in a changing area. And those are just the charges we've brought so far that relate to the victims that we can identify. As the sheriff said, we fully expect and actually know that there are thousands and thousands of images and videos that we will have to work, law enforcement in partnership with others, to identify who those victims are. And those are all being investigated. I also want to say that this is, there are so many victims that we know about and a lot we don't know about. But this individual preyed not just on parents and community members and trust, but also in our well-respected institutions and hospitals, who I do want to point out have been very cooperative and are working to see those victims identified and want very much to work with law enforcement to hold him accountable. I can't stress enough the amount of hours and hours and hours of work it takes for the computer crimes section of the sheriff's office, and they have been doing that almost around the clock for over a week. These are difficult images to view, and it will take some time. We wanted to be cautious and careful about what we release to the public because we don't and can't identify all the victims at this point. We now have ability to access information and digitally analyze so much evidence, and because of that are bringing these kinds of horrific acts to light. But it takes a partnership with our law enforcement, and we rely on the computer crimes section a lot, and we are continuing to work together to make sure we can identify all the victims in this case. Thank you.
Questions?
Are the allegations all that it was just, not just, but that it was on camera, he was recording people, videoing people, or is there any that he was actually sexually abusing people?
Oh, yeah, he definitely sexually abused some of the folks, even on camera.
Since he's an Indian citizen, is this investigation going to go across international borders as well? Are you in touch with Indian police?
Well, that, as I said at the outset, I think that's a good possibility. It will end up in multiple states, potentially multiple countries. So as our computer crimes unit, who unfortunately has the task of seeing this disgusting stuff nonstop, if we're able to either use geotags or other kinds of things that will help us determine where things happen, it will just take it where it is, and then obviously engage with our international partners as well.
So far, how many victims do we have?
I can't even put a guess on it because there's so many images.
Ones you've identified?
We haven't identified many of the victims, but we have multiple people that are captured on film in different states of complete undress, or where they are appears to be under some kind of anesthesia, and they're being violated. I can't even put a guess on it at this point.
Are you able to share how did this crime come to light?
We were given information by his wife.
Are the 5 victims who are in the charged cases, they're in court records as Jane Doe and John Doe. Does that mean they're not identified yet, or are you just protecting their identity?
We're protecting their identity. The current charges that we've issued from the events that we've identified have occurred in Oakland County thus far involve 4 separate victims, and we absolutely have identified them, but are trying to protect their privacy.
Can you tell us what was the swim club in Rochester Hills, the name of it?
Yeah, and again, as the prosecutor said, the hospitals and the swim location are victims in this as well. There is no information at all that they had any idea any of this behavior was going on, but it was the goldfish facility in Rochester.
And they've all been very cooperative.
Super cooperative.
Can I just clarify, the victims that have been identified, the 4 victims in the currently charged case, where were those victims at? Obviously, we know Goldfish facility in Rochester. Was there another hospital as well, or were the victims all from that swim school?
The currently charged cases are stemmed from the swim school, and it is a 2-year-old, a 4-year-old, and 2 adult females.
Were these devices placed in areas that he had specific access to, or could they have been, more public places no one would expect him to be able to plant a device like that?
Yeah, it looks like he's potentially using a variety of camera options, including something that may have been accessible, maybe even controlled by a device, and some things may have been just his cell phone. I mean, that's still a work in progress, but it looks like, again, there's sometimes opportunistic moments when he does it, and other times where it looks like he has intentionally planned the moment.
And just for clarification, I know you guys talked about this, but this time with the kids, this most recent time, I think, Karen, you were talking about this stemming from the woman changing her children. Was he physically, holding something? Is that how he got caught?
No, he was not caught there. They were unaware. This was discovered on the hard drives that we were investigating. So the camera looks like it's looking underneath into their changing room. And whether what that actual device looked like. I'm sure we'll get into some more of the evidence as this case proceeds, but he obviously had been examining and researching cameras to do a variety of surreptitious activity.
So he was never physically with the camera with these recordings?
Oh, no, he was with cameras, absolutely. On some of the videos, he actually shows himself.
I understand there's a lot of evidence to go through. So far, how far do you see this sort of activity dating back to?
Well, I detailed what we've seen so far, so I guess, that's the current range. If they find out there's cloud storage, we don't know what may or may not be there. We don't know the depth of, we don't know what we don't know. We just know it's massive, and they've got thousands of hours ahead of them to run through and determine if something looks to be criminal, and then that gets handed to the prosecutor, and then they keep going.
And where was he arrested?
At his home in Rochester Hills.
One last question for me, at least. The court document shows that his age is 40. So is there a discrepancy there?
I was early on told he was 37. Detective, anybody?
So sure, really, he's 40?
We'll confirm that with you. Or when this started percolating, I was told he was 37. Once we kind of had him in our sights, we focused more on what he did, not necessarily his date of birth, but we'll get that to you.
And in the charging documents, I just want to clarify on the number of victims. It lists 4 Jane Does and 1 John Doe. So are there 5 or 4 victims in that case?
There are 4 victims.
Sorry, one other question on the goldfish facility incident. So the offense date on the online court record shows August 21st, 2023. So this was an event that happened last summer that was seen on the hard drives. That's how you connected that case. Is that correct?
Correct.
It was from last year. Okay.
Correct.
What would you guys say to victims who might see this, who are a little nervous to come forward, even still with his face out there and everything?
That's why we gave an email so that they could do it, in a way that's hopefully not fearful for them, that they don't have to, physically come in. They can send in information, and then we can begin to make sure that they understand we're on their team. If they're a victim, we're going to do everything we can to protect them, but also to hold the perpetrator accountable for what was done to them.
And for the thousands of videos that you were talking about found on the hard drives, is that believed to be all like pornographic images?
We have to go through it. Yeah, I mean, some of these last an extended period of time, and you may watch the whole thing, and there may be nothing that appears to be criminal, and other of these videos, it pops up immediately like, oh my gosh, where is he now?
I do want to point out that the charge of child sexual activity, abusive activity, is related to a underage individual who is not named. We don't know the identity, but it's of pornographic nature, and just the possession of that. That's what that charge relates to.
And that's not related to the swim school.
That's correct.
So he's not charged with creating child porn at this point then?
He is charged with 1 count of child sexually abusive activity. So that means it's on his device.
Possession of a child.
Well, the charging language is did attempt, prepare, or conspire to arrange for, produce, make, copy, reproduce, or finance any child sexually abusive material. So that might be why you were thinking there were 5. 1 is unidentified.
So 4 identified, then the 1.
Yes.
Do we have a correct pronunciation of his name?
That's the best information I was told.
Ajaz.
Sorry? Ajaz.
Omer
Ajaz. There we have it.
Can you just read that list of charges again? I wasn't quick enough to jot them down.
Sure. I have it written down here. One count of child sexually abusive activity, 1 count of using a computer to commit a crime, 4 counts of using a computer to commit a crime, and then 4 counts of capturing and distributing image of unclothed person.
How many charges?
10 total.
For the video that you mentioned of the woman unconscious in her hospital bed, was he there as a doctor or somebody visiting, or are you not sure at this point?
There's not just one. There's not just one.
Yeah, she was mentioned that there's more than one.
Oh,
unfortunately, a woman that appears to be in that situation, whether that was an individual he had been charged with any kind of medical care of, or he just accessed that room on his own, or if he went there on his own time because he had credentials. All of that's part of the investigation.
And not the subject of any charges at this point.
I also noticed there's a distribution charge as well. Is there an aspect where he was distributing those images somewhere?
There's 5 counts of using a computer to commit a crime, 4 counts of capturing, distributing the image of an unclothed person. Those relate to the Goldfish Swim School. 2 of the victims were not minors.
And to put a kind of an exclamation point on your question, at this point, our computer crimes unit hasn't determined he had sent these or shared these elsewhere, but these were his. But that's still going to be part, if they find in the computer or the devices that he had been communicating or sharing. If you remember a very terrible case we had many, many years ago, we started with a few victims at a home in Oakland County and found out it was a national network of that they would do the victimization and then share it. And we don't have anything on that at this point, but that doesn't mean it's not there.
And you compared this case to the Nasser case. From what you've seen so far, does this have the potential to be bigger than that because of his victimization pool?
Yeah, I mean, that's what concerns me, is that as terrible as that case was, it was based on actual patients in front of him, typically in a certain kind of target victimization. This has no target. It's completely random. It can be a stranger. It can be a person in a medical setting. It can be someone in his home. It can be anyone.
Just to clarify, sorry, it sounds like maybe the date I'm looking at on here concerning the swim school might not be accurate. What is the date of the offense on the swim school incident?
That was in August 23.
Is it all from one event, or is it from multiple separate incidents?
It stems. It's not just from one day. So there's a range.
Does he have a medical speciality?
He's an internist.
So what hospital? I mean, you said Henry Ford McComb. Is that who he's been most recently?
And no, I also said another one. So those are the 2 that we're distinctly aware of. Henry Ford McComb and Ascension Genesis. But, there's the potential for him to have been elsewhere, and that's still, as I said, if any other medical facilities had him credentialed or any other victim is aware of him being in another facility, we would like that information.
And there's nothing public on Lara about a history of issues with his license. Are you aware of anything?
We have no criminal history on him or any other complaints prior to us getting tapped into this early this month.
Is there anything people can do to make sure that this doesn't happen to them? I mean, if they're going into, a public facility like a swim school or even a hospital, what can you do to prevent this?
Yeah, that's probably one of the most disturbing parts. Is it's so unsettling because it's so random and it's so prolific in different venues. So you don't think about certain things, and we in law enforcement think about the worst thing all the time. We're always looking. But, I hate to tell people, but when they go into a changing room, you're going to have to be aware. We know that. We've seen that in people that put cameras in hotel rooms and left them, and they've done a variety of things. It's one of those things where you just never know. You should be situationally aware is what we tell people. Certainly, if the changing room, like in some situations are, like if you go to a department store, sometimes the changing room doors are almost like bathroom stalls. They don't go to the floor. Lots of times we'll see individuals using that at the top or the bottom, because it's not a wall all the way to the ceiling. There's a variety of ways that this is accomplished. Just try to be situationally aware. But we hate to make people paranoid, but unfortunately we've got some very sick people in this world. So that's one of the things we were actually chatting about in the medical setting. Obviously, if you can, have somebody with you as your loved one when you're undergoing any medical procedures and when you're, coming out of those procedures, if at all possible, to have somebody with you. Because, again, the hospitals have been super cooperative and they're super unaware of all this. But because of his access and credentials, he could move pretty fluidly into some of these different situations.
Are you working with other law enforcement agencies?
We've already advised the different police agencies in the communities we're aware of what we're working on. There's going to be a meeting in the near future with detectives from those agencies. And as this, spins out, if it gets a lot bigger, we may have to create a task force at some point, potentially, because it may be, as I said, something that grows exponentially depending on what they find and see.
Can you say what those agencies are that you're working with right now?
Well, the two venues that you have, obviously, you got Genesee and Macomb. So the Clinton Township and Grand Blanc Township are two of the agencies where those were the venues of stuff we've at least identified. We've already communicated with Rochester City Police, but that's within Oakland County, but they're also looped in on this as well.
So this isn't just a case of him setting up cameras, getting his videos, and everything. You've actually got a video of him assaulting people. Is that what I'm getting?
Yes. It goes beyond just capturing video. There's physical, assaultive, criminal conduct.
How did he get access to the swimming pool? Did he use his kids to be able to get in? Or?
That's still under investigation. Yes, they have kids. Yes, they've been there. On those days in question, we don't know whether, his kids were there. That's still part of a work in progress. I wouldn't put it past them, given what we've seen, to utilize, children to put himself in a position to victimize other people. Again, going back to that one case, that individual had young kids, I think about 6 years old, and invited other kids over for play days and then victimized those kids. So, when you get somebody with a very sick predatory predilection, they utilize their access to get other victims.
That's not him you were just talking about, right?
No, I said that earlier case. So that, to the question of how did he access certain areas where there were kids, we're not sure at this point whether he went in there with his kids to get into that location to be able to do that, or whether he was able to get in alone.
But you did say in the press release that, or bulletin, that this happened in the swim club, hospital, and then also you said in his home, correct?
Yes.
So can you elaborate on that?
Use of the cameras, use of other things, we're just, again, scratching the surface. But based on that evidence that they've seen, they've been able to identify some of this occurred in private homes, including his.
What happened in his own home, if you're able to talk about that?
Capturing images of people when they were not aware.
Like wife and...
Beyond that.
Just to be clear, these are explicit images of people. It's not just like capturing images of folks. It's like he's capturing.
Right. Not just taking a picture of someone having a cup of coffee, taking pictures while they're in the bathroom naked, as an example.
And how many kids did you say this guy had?
Sorry?
How many kids did you say he had?
2.
Are we able to talk about the gender?
About what?
Gender of the 2 kids?
2 young boys.
If you could get the clarification on his age, that would be helpful to all of us.
We'll get that. If somebody can check his booking, we'll get that right now.
40.
He's 40.
Okay. Thank you very much. Thank you.
Thank you.
Thank you.
Looks like she's relaxing in a lawn chair with a good book. But authorities say she actually just torched her own home, then sat in the chair to watch it go up in flames. The shocking video starts with the woman having an argument on her front porch.
Oh my God, he just threw water at her.
Then another argument with another resident. Next thing you know, the house they all live in is on fire. And there's the accused arsonist relaxing in the lawn chair.
She's sitting there just chilling, watching the house go up in flames.
The fire quickly consumes the house in Elkton, Maryland.
Get out of the house! It's on fire!
A bystander runs to help a resident as she climbs out a window.
Hurry!
Fire crews rush to the scene.
That whole roof just fell.
Avery Hammond shot the video.
I couldn't believe that she was just sitting there like it wasn't happening. She casually went out there, sat in a chair, stated a few obscenities, and watched the fire spread throughout the house.
47-year-old Gail Metwally was taken into custody. She reportedly has mental health issues.
She's sitting there just chilling, watching the house go up in flames.
Count them, roughly 65. That's how many Stanley Cups cops say were stuffed in the trunk, and even some more in the front passenger seat. Most of them, investigators say, were stolen from a Dick's Sporting Goods store in Roseville, California, outside of Sacramento.
So we have these at Dick's Sporting Goods, and they have some wonderful benefits and features.
The 40-ounce quencher, which retails for $45, of course, has been in high demand and have been hard to come by as they've been selling out. A quick search of Dick's Sporting Goods website, a few various colors are available, but how so many of them were even on store shelves in this theft case is anyone's guess. Police aren't sure, and Dick's Sporting Goods did not return our request for comment. According to law enforcement, an employee saw a woman take a shopping cart full of Stanley water bottles without paying for them and then stuff her car with them. Officers were alerted, and the suspect was pulled over as she was getting on the highway. They value these goods at about $2,500. $300,000 worth of stolen Legos have been recovered. Take a look at the goods, from Star Wars to Lord of the Rings themed merchandise. This was the collection California Highway Patrol say they discovered during its investigation into organized retail theft. A few months ago, in an unrelated case, police in Upland, California say this shirtless 22-year-old allegedly took off with $1,700 worth of toys from the store. Lego larceny has been an ongoing issue across the country. Some limited edition Legos, like Luke Skywalker's land speeder, can cost $239. This Millennium Falcon set is $160. A possible motive? Their resale value. Items are being stolen from stores and then resold to unsuspecting buyers on online marketplaces. Here's Stephen Fabian.
How bad is the problem? This Las Vegas store, Bricks and Minifigs, opened a year ago and already has been hit 4 times by robbers seeking Lego sets. In this instance, you see a man reaching for Legos on the top shelf, where the most expensive ones are on display. Keep an eye on this suspect. He's carrying 2 Lego sets, then grabs another and hightails it out of the store. And in this surveillance tape, 2 guys meander around the store. After a few minutes, they make a break for it, each with an armful of Legos.
They ran out with about, I would say, $1,800 worth of product, probably close to $2,000.
Store owner Edgar Garcia showed us one of the things that makes his store unique, but also vulnerable: shelves of Star Wars Legos.
This is where we have some of our most expensive Star Wars sets, some of our most collectible ones, and unfortunately it's also where our latest thieves stole from.
As for the $300,000 case, 4 suspects were arrested and booked on charges related to organized retail theft, grand theft, and conspiracy to commit a crime.
It all started with an online post that some people at eBay thought was harsh. It ended with 6 eBay employees facing charges of...
Were this woman and her husband the victims of a shocking campaign of terror by eBay employees?
This case definitely is baffling.
Ina Steiner and her husband David were sent a box of live cockroaches and spiders, as well as this book, Surviving Loss of a Spouse, and this Halloween pig mask, say federal prosecutors.
Pizza delivery for Hitler. Hissler.
The scheme was allegedly inspired by the 80s teen movie Johnny Be Good, in which 2 knuckleheads harassed their football coach with off-the-wall deliveries.
No, it's for nobody. Get out of here now.
Prosecutors say the eBay employees all worked for the company's security and global intelligence team. It's being called one of the strangest corporate scandal cases in recent memory.
Definitely one of the most bizarre cases I've heard of in the business and corporate world, not just recently, but really in history. I mean, how many times have you heard about intimidation with live spiders and live cockroaches?
So why were the Steiners targeted? Authorities say they published an online e-commerce newsletter and ran articles and anonymous commentary that were critical of eBay. The 6 eBay employees have been charged with cyber stalking.
You can imagine that a Fortune 500 company that should have higher standards, corporate standards, and set themselves at a higher bar, their brand might be tarnished.
eBay says in a statement, eBay does not tolerate this kind of behavior. eBay apologizes to the affected individuals and is sorry that they were subjected to this. eBay terminated all involved employees.
5 men have been convicted of stealing jewelry containing over 4,300 diamonds in Germany. Security footage showed masked people breaking into the Greenwald Museum inside Dresden Castle in November of 2019. Glass was shattered and the thieves made off with 21 pieces of 18th century jewelry and artifacts. A sword measuring 38 inches long and covered in 800 diamonds was among the looted items. Overall, the haul was valued at about $123 million. The group of 5 men, who are all members of the same family, were caught in Berlin, about 120 miles away. It took several months for authorities to arrest the people responsible for both the robbery and the deliberately set fires that cut power to streetlights the night of the crime. According to the judge in this case, the thieves were able to cut a plea deal because most of the artifacts were returned. They'll each serve 6 years behind bars. But not all of the antique jewelry has been found, and some fear the stones have been removed and the gold and platinum melted down, never to be seen again.
A Florida man allegedly has a taste for rare and expensive things, and cops say he didn't pay for them. St. Petersburg police arrested a man who they say was in possession of 2 stolen Galapagos tortoises, as well as rare books. Authorities say the animals were taken from the St. Augustine Alligator Farm Zoological Park in November. Cops say when the turtles found at the home were scanned for chips, they were identified as the ones that went missing. Police also say the suspect had an outstanding warrant for a commercial burglary where thousands of dollars of rare comic books were stolen. Unfortunately, cops say one of the turtles was found dead in a freezer, but the other was alive and found in the suspect's yard. Properly cared for, Galapagos tortoises can live to well over 100 years. But they are endangered, and these had an estimated value of $10,000 each.
It's called Operation Viper. After several years undercover, the Florida Fish and Wildlife Conservation Commission Division of Law Enforcement charged 8 people with trafficking venomous and illegal snakes.
So it took an extensive team over 2 years to really get the information that needed to prosecute these individuals. This case was unlike any other, normal with fish or meat. You just have to deal with the nefarious actors. This case, they had to beware of the actors and as well as the product that they were selling or buying, very dangerous reptiles.
According to authorities, almost 200 snakes, 20 different species from 7 regions of the world, were purchased or sold to and from wildlife traffickers during Operation Viper.
Countless cobras, gaboon vipers, bushmaster snakes, inland taipans from Australia, many extremely dangerous snakes.
Officials say deals began on the black market using special websites and social media pages, and they transitioned into in-person meetings. Lorincz says the team trained hard to pull this off.
There's a lot of additional training. A lot of them were already capable of handling venomous reptiles, but we went above and beyond and gave them extensive training on handling some of these snakes.
The reptiles are a massive threat to native wildlife in Florida.
These rules are in place for public safety and also to protect Florida's ecosystems. A lot of these animals could really be injurious to people, but also they're imported from all over the world, and they bring disease with them and could affect our natural habitat.
In addition to the alleged crimes with the animals, FWC investigators say they documented other non-wildlife crimes, and there still could be more arrests.
The investigation is not over today. This was just the first phase. We are going to continue to investigate other nefarious actors in the trafficking of these venomous reptiles.
It is estimated that illicit wildlife trafficking makes $7.8 billion to $10 billion per year, according to the Wildlife Conservation Society.
Trafficking is an extensive problem globally, and especially in the state of Florida.
Here's a tall tale from Illinois. Cops in Quincy say someone broke into a laundromat after hours and robbed the place wearing a bunny costume. It could be a sign that the suspect was out of clean clothes and had to wear an old Halloween costume to leave the house in decency. Even investigators couldn't believe what they were watching on surveillance video of the incident, writing on Facebook, "File this one under 'You can't make this stuff up.'" The suspect spent just over a minute inside the business grabbing whatever they could get their paws on and then making a getaway. Now cops want the public's help in identifying and apprehending what they are calling a furry felon.
You have never seen a porch pirate like this. Watch as this garbage bag shuffles up to the front door. All you can see are fuzzy slippers. The knucklehead grabs the small package and scurries off. The homeowner in Sacramento tells Inside Edition that at first he thought it was a prank, but it was all real. And speaking of porch pirates, clear across the USA in Queens, New York, another porch pirate suspect walks up to a house and definitely got more than he bargained for. Watch as he casually grabs a package off the stoop and stuffs it in his backpack. But he never expected this.
Yo.
The homeowner comes after him with a bat.
What you got in there? Nothing, man. What you got in that bag? Yo, this is my stuff. Yo, you can have everything, bro. Yo, I live right there, bro. Get on your knees. Get on your knees right now. I live in the
I spoke to homeowner Carlos Mejia today.
What led you to pulling out a bat on a porch pirate? I mean, what brought you to that point?
Got tired. Just tired of people taking my stuff. Like, it's not the first package. I was nice this time, but I won't be nice the second time.
I live in the
This woman is walking out of her house. Just an ordinary day. Suddenly, she screams. What's that sound? Oh no, it's a gaggle of geese, and they're coming for her.
This is not the smartest criminal in the world. He was caught on camera with a cardboard box over his head while allegedly stealing phones from a store in Florida. But at one point, he lifted up the box, giving cops a clear view of his face. He was arrested a short time later at a nearby liquor store.
Owners of this store in England let an attempted robber go free. Surveillance video caught what looked like a customer browsing through the Phone Market, a cell phone store in West Yorkshire, UK. After getting two phones in his hand to compare, the hooded man makes a run for the door, only to find out that it's locked from the inside. The would-be thief brings the phones back to the counter and makes his excuses. The two men behind the counter remain calm. But they didn't. The shop owner, Afzal Adam, not only let the suspect go, he posted the video to Twitter asking the almost robber to come back. He wrote, "The times are difficult for many of us at the moment, so if you are struggling to put food on the table, please come visit us in the store to see how we can help." Adam credits his Muslim faith with teaching him to be merciful and forgiving.
How creepy is this? A surveillance camera catches a man crawling around an attic. Down below, this family's bedroom, where this couple sleeps. Next to the bed, their 10-month-old baby girl's crib.
For all these years, we have no idea what's been going on inside our own home.
Jerome Kennedy and Ashley live with their baby Reagan in an historic home in Pittsburgh. The row house next door being renovated is owned by 69-year-old Robert Havrilla.
He's very reclusive. He keeps to himself.
Last month, Jerome was in bed when he heard noises in the attic.
I knew that somebody was up there.
Then he says he noticed a light shining through a pipe.
Then I saw the light right through there, like it was searching for a place to look through.
Jerome decided to install a surveillance camera in his attic.
That's him right there.
A day later, caught on tape, was his neighbor carrying a power drill.
I think that he was looking into the bedroom.
Jerome discovered his neighbor had made a removable wall to gain access to their attic.
There was originally a wall here that he had removed.
And it wasn't just the attic. Jerome also found holes in a common wall. He quickly plugged them up with tissue paper.
You can see those holes. They look perfectly round.
The couple's attorney, Jack Goodrich.
It's that scary to think that somebody would be that intrusive into somebody's home. In my humble opinion, he was waiting for the creep show.
Cops were called and Robert Havrilla was charged with stalking and trespassing. He's pled not guilty.
I think he should go away for a long, long time.
So that we can sleep soundly at night.
This guy sure looks like he's selling candy door to door, but something sinister is about to take place. Watch what happens when the homeowner in Stockton, California opens the door to buy a box of candy. Out of nowhere, 3 guys burst into the house. It's a home invasion. You can hear the woman screaming in terror. The Candyman takes off. Earlier that day, a neighbor's security camera caught Candyman trying to pull the same stunt, but this time the homeowner refused to open the door. He spoke to Inside Edition in a mask to protect his identity.
He was very fidgety. He kept looking over his shoulder. He was kind of like, rocking left and right, like he was just like very anxious or nervous about something.
Candyman leaves and heads across the street. Was he on the lookout for his next victim? And this is another terrifying home invasion. It happened in Oklahoma. The homeowner answers the door. Then suddenly he's trying to push it shut, but he's overpowered by 2 men posing as maintenance workers. One has a gun, the other a taser.
They pointed the firearm at the victim there in the living room, made him lie down.
There's a tussle. You can see the taser go off. They finally leave, getting away with his phone and keys.
Make yourself at home, why don't you? This is the hard-to-believe moment a total stranger breaks into a house in Portland. The woman makes her way to the boy's bedroom and climbs up, then proceeds to lie down and take a nap next to that pile of clothes. The family's 2 dogs go nuts, but the intruder doesn't seem to mind at all. Now watch what happens when the homeowner realizes something is wrong.
Oh my God, Justin.
At first she thinks, must be her husband. Then it hits her. She raises the alarm with a friend she's on the phone with. Goldilocks isn't happy her beauty sleep has been disturbed. She picks up an ottoman and throws it at the mom. Then she takes off with one of the not-so-great guard dogs at her heels.
I saw a dirty foot sticking out of the top of the bed.
Homeowner Kelsey Smith tells me she had left the front door unlocked because contractors were coming and going.
You must have been freaking out.
It was more confusion, honestly, at first, and then she charged at me. It's not a good feeling.
The DA declined to press charges against the intruder.
Who's that at the door? Coke, is it? The pause that refreshes and allegedly robs a restaurant. A man wearing a Coke bottle costume used a gun in the crime, police say. The felonious refreshment made off with $500, they add. Maybe the crook should take a lesson from other Coke bottles and learn to get along.
I like to teach the world to sing with me.
Cops in this Kentucky town urge anyone with information about the real thing to come forward so they can put the Coke side of life behind bars.
State troopers in Vermont say when they tried to arrest a man, his dad tried to attack them with an excavator machine. The state police say 2 troopers went to arrest 24-year-old Brandon Tallman after he allegedly had an altercation with his neighbor. But as they attempted to handcuff Tallman, the troopers say his mother tried to stop them. And then his father maneuvered his excavator's bucket near the troopers and their vehicles, causing them to retreat.
For all available units,
units. I've got 343 and 254 and a 1010.
Now the whole family faces charges in connection with the incident. Brandon Tallman has pleaded not guilty to aggravated assault, burglary, unlawful mischief, and resisting arrest. His father, Wayne, is charged with aggravated assault on protected officials, resisting arrest, impeding, and reckless endangerment. The mother, Amy, was given a citation for impeding and is ordered to appear in court in August.
A man is caught on camera leaping from the second floor of an apartment complex and running into an ambulance, and then driving off with it, as first responders were attending to a medical call. This is video from inside the emergency vehicle. Huntington police in West Virginia believe this is the suspect, Anthony Bell. Police say the ambulance crashed into a home and was abandoned. No one was hurt. But police are now looking for Bell. Anyone with information is asked to call police.
A mother testifies before Congress about a terrifying day.
Nothing could have prepared me for her response that she gave me next.
It started with a phone call to Jennifer DiStefano. On the other end, she hears her 15-year-old daughter, Bree, crying. They first told their story on Inside Edition in April.
She's like, "Mom, I messed up," as she's crying and sobbing.
Then a man gets on the line and claims he's kidnapped Bree.
He's like, "Listen here, I've got your daughter. You're not going to call anybody. You're not going to call the cops." I just put the phone on mute and started screaming for help. "Mom, these bad men have me. Help me, help me, help me."
They demanded $1 million, then lowered their ransom to $50,000. But her daughter had not been kidnapped. It was an artificial intelligence or AI scam. Phony kidnappers duplicated her daughter's voice using AI.
How did they get her voice? How did they get her crying, her sobs that are unique to her?
Berkeley professor Hanny Farage showed our Allison Hall how it's done. The AI expert took examples of her real voice and cloned it.
I went over to YouTube and I searched for your name and I found an interview that you gave. It took me all of 5 seconds to do that. I uploaded that to a web service that I pay $5 a month for. In about 30 seconds, it cloned your voice. I typed what I wanted you to say, and it handed me an audio file back. That whole thing took me under 5 minutes to do.
So I have the recording that you made. I'm going to play it right now.
It's Allison. This is going to be hard to believe, but I've been kidnapped. They want $1 million ransom. Otherwise, they say they'll hurt me. I don't know what's going to happen. They want me to hang up now. I've got to go. I love you.
That's pretty creepy.
Fortunately, DiStefano was able to reach her daughter before paying the ransom.
I was in Flagstaff skiing with my little brother. My mom called me and she was crying, like bawling, crying.
Now this AI victim is going to Washington, warning the nation about the potential dangers of artificial intelligence.
When your child calls in need of help, will you end the call and say, "I don't believe it's really you"? Is this our new normal?
Do I look like a seventh grader? No? Cool. Awesome.
A 30-year-old woman was arrested after she impersonated her 13-year-old daughter at school.
Oh my goodness. I am gonna get so caught. I'm actually really scared now. I am literally on the campground of a middle school.
Casey Garcia donned a yellow Marvel hoodie and even dyed her hair darker in order to look more like her daughter, a student in 7th grade. Then she says using her daughter's student ID number, she went to school.
I then said hello to the principal, and then I spoke to another faculty member, and then I went to all my classes. I even ate lunch without a mask.
Garcia says teachers were more concerned about the fact that she had her phone out and that it took until the last class of the day for someone to recognize she wasn't her daughter.
I wanted to see if I could make it the entire day without anybody noticing. And I'd say up until 7th period, I think that's a very long day for a 30-year-old.
On her YouTube channel, Garcia says she was not intending to embarrass the school.
Well, I finally got caught. I told them that I would go to the principal's office.
But to test campus security and shed light on a bigger issue.
We have a problem. There have been one too many mass shootings in schools, elementary schools, colleges, high schools. That is disgusting to think of, that this could have been prevented just by putting metal detectors and more security.
Yes, sir. How can I help?
El Paso County Sheriff's deputies arrested Garcia 2 days after she posted the video of her at school, an interaction that she also recorded and posted online.
What made you guys come down?
Oh,
Besides the viral video.
what they sent us to come. You have a traffic warrant, so that's what we're here, man.
Besides the unrelated traffic warrant, Casey Garcia was charged with suspicion of criminal trespassing and tampering with government records. She has been released after posting bond. In a statement to KTSM, the San Elizario Independent School District Superintendent said, while there was a breach in security by an individual associated as a parent with the school, we want to assure you that our security measures are being reviewed and evaluated. Casey Garcia also told KTSM, I spent the day in police custody, but my question still remains, are our children safe in our schools?
We need better security at our schools. This is what I tried to prove. And I don't mean to be curt, but I kind of feel like I proved it.
This is Inside Edition Digital. Powerful stories that change the way you think. Impactful investigations that change the way you see.
How many times has your car been stolen?
5 times.
Yeah. What? Do you think that you're a responsible owner of tigers?
I damn sure do.
Heartwarming moments that change the way you feel.
Amazing.
Now available in a place that changes the way you watch TV. Inside Edition, streaming.
A curator for a world-renowned museum was detained by authorities in Turkey on suspicion of smuggling venomous arachnids out of the country. Lorenzo Prendini is a curator at the Museum of Natural History in New York. His profile on the museum's website says he's a curator of the arachnid and myriapod collection. Reports say he was caught at an airport in Istanbul with plastic tubes and bags containing about 1,500 dead scorpions, tarantulas, and spiders that are endemic to the country. Some of these species produce venom that can be used to produce medication, according to state-run media. He was reportedly detained under the country's anti-smuggling laws. However, Prendini tells Inside Edition Digital he was cleared of all charges by a Turkish judge because he had the proper permits to leave the country with the specimens.
Another brazen shoplifting inside a Walgreens in San Francisco. Just look at the suspect's shameless thievery. He's actually behind the counter, filling his bag with loot, seemingly without a care in the world. Then, as he casually leaves, he knocks the cell phone out of a customer's hand, and the two go at it.
Where you want to go?
What happens next will shock you. It's a food fight. They literally go bananas at each other.
No.
The customer retaliates by throwing more bananas at the bad guy, hitting him in the back. There's more. This time, Chips Ahoy cookies are flung right at the suspect.
Hey, stop!
San Francisco-based photographer Nicholas Stennett shot the crazy video.
I definitely didn't anticipate a food fight in the middle of a Walgreens. Bananas flying, cookies flying. It's definitely a unique situation.
Hey!
I don't think Santa Claus had theft in mind when he picked Rudolph to guide his sleigh on Christmas. Instead of dropping off presents at people's homes using the chimney, this red-nosed reindeer was stealing goods at a Colorado business, cops claim. The alleged crook, disguised as Santa's #1 helper, was caught on a security camera. At one point, the suspect removes the giant costume head, but eventually puts it back on. Police poked fun at the pillage, writing their own parody song to that famous Christmas tune.
Rudolph the red-nosed burglar had a very shady scheme, and if you saw the video, it would make you want to scream. All of the other burglars used to steal without disguise. They weren't like this old Rudolph. She's different from the other guys. On one foggy December eve, Rudolph came to steal Broke into a hickory shop and never expected to see a cop. Oh, how the camera caught her as she committed burglary. Rudolph the red-nosed criminal, we need your help with her ID.
This woman has just pleaded guilty to being the long-sought killer clown who murdered her rival 33 years ago.
My mother was gunned down, murdered by a clown.
In 1990, Marlene Warren answered the door of her home outside West Palm Beach to find a woman dressed as a clown delivering flowers and a balloon reading, "You're the greatest." Suddenly, the clown pulled out a gun and shot Marlene in the face before fleeing in this white convertible. The shooting was recreated for this 2020 story.
Mama, rest in peace.
Joseph Aarons was 21 when his mom was slain in front of him.
I heard, "Oh, how pretty," and then I heard bang.
Suspicion quickly fell on this woman, Sheila Keene. Police believed she was having an affair with Marlene's husband. Both denied any romantic relationship. No one was charged, and the case went cold. But detectives kept at it. They even unearthed this Halloween photo of the suspect in clown face. 12 years after the murder, to the shock of many, Marlene's widower, Michael Warren, married Sheila Keene.
A jealous mistress who wanted Michael Warren for herself. And then years later, they got married.
The Warrens moved to Virginia where they started a new life. Then, in 2017, she was arrested after her hair fiber was found in that getaway car. Now the case is finally over. Keene, now Keene Warren, has just pleaded guilty to second-degree murder. But as part of a plea deal, she may get out in 10 months due to time served. For the victim's son, it's enough.
We finally have closure. Now she can rest.
Imagine getting a phone call that someone has abducted a loved one and will kill them if you don't pay up. It happened to this woman who'd been told that her sister had been kidnapped. Well, it was a fake call, part of a growing new scam called virtual kidnapping. Lisa Guerrero has more.
It's a frightening call.
I was terrified that he was going to kill my sister.
This home surveillance footage shows Beth Royce on the phone with a man who claimed he had kidnapped her sister.
I'm here. Don't do me like this. I'm sorry.
She says what made it all seem so real is that the call came from her sister Kayla's phone number.
It looked exactly like she was calling me. I have a picture for her for the contact that popped up.
She says the caller demanded money or he'd kill her.
He was saying that I'm going to shoot your sister in the head. He said he was going to shoot your sister in the head. Those were his exact words. I heard crying in the background.
Panic-stricken, Beth, who lives in Pittsburgh, says she quickly transferred the kidnapper $1,000.
Okay, I'm going to pay you right now. It was the scariest moment of my life.
Beth's mother, Rosemarie.
She came rushing in my room, saying they've got Kayla.
Rosemarie called Kayla's cell phone. It was 4 a.m. in Seattle, where Kayla lives, but thankfully, she answered.
And I screamed. I said, "Oh my God, Mom, what is happening?" And she was like, "Beth is on the phone with somebody who says that they have you kidnapped." And I was like, "Well, they don't. It's me."
That's right. It was a sophisticated scam known as caller ID spoofing, in which scammers make it seem as if the incoming call is coming from someone on your private phone contact list.
I just started crying once I found out she was okay.
The next call she made was to the police. Beth's Ring camera captured the moment 2 officers arrived.
So this is Ring footage of the actual phone call that's happening.
They're called virtual kidnappings, and the FBI says they're on the rise. Listen to the call another woman got from a virtual kidnapper.
The life of your husband is in danger right now. You going to help him or no?
He's in danger?
Of course, because my brother wants to kill him. Listen, sweetheart, your husband got his jaw fractured. He's bleeding.
Well, why are you hurting him?
Now Beth Royce is trying to get the word out.
I need to tell everyone about a really bad scam that I experienced today.
And the FBI recommends if you do get one of those calls, among other things, ask to speak directly to your family member. And if they won't put them on the phone, get them to describe them or maybe the car they're driving. and try to keep them on the phone as long as possible.
5 years ago, it dominated the headlines. California mom Sherry Papini claiming she was abducted while jogging and held captive by 2 Hispanic women. But there have always been questions about her story, and now she's under arrest.
She made it all up. That's the bombshell allegation leveled today against Sherry Papini, the mom whose supposed kidnapping in 2016 as she jogged riveted America. Prosecutors now say Papini's headline-making story was fabricated. Sherry Papini was reported missing by her husband, Keith.
Bring her home safe. There's a $50,000 reward. Bring her home.
22 days later, on Thanksgiving Day 2016, she was found wandering, bruised, dazed, and branded. She claimed she'd been kidnapped at gunpoint while jogging by 2 Hispanic women. But now, cops say Papini faked the kidnapping. They say she arranged for an ex-boyfriend to pick her up while jogging and drive her 600 miles to his home in Costa Mesa, California. During the entire time the nation was looking for her, Papini never left the ex-boyfriend's residence, the criminal complaint says. According to authorities, the ex-boyfriend says Sherry Papini actually asked him to brand her. He says he drove to this Hobby Lobby and bought a craft tool like this. It looks like a soldering iron, and it's normally used to burn patterns into wood. He allegedly drove back to Sherry, heated the tool, and then branded her on her right shoulder with what is believed to be the word Exodus. To build up the evidence that she'd been kidnapped and tortured, Papini allegedly purposefully hit her head on the bathtub and the bathroom floor. After 3 weeks, Papini allegedly told the ex she missed her children and said, "I'm ready to go." He drove for 7 hours and dropped her off on a country road 150 miles from her home. The boyfriend has not been charged. I spoke today to the woman who saw Papini at the side of the road and called 911. How do you feel now when you see these allegations that this entire thing was made up?
Betrayed. If it's true, I'm angry.
Bobby Chacon is a former FBI agent.
Every woman in that region was afraid to go out, to go jogging, to go walking.
Private investigator Cody Salfan, who took part in the search, says Papini fooled so many people.
I feel for her family. I'm sure that Keith, her husband, I'm sure that there's a huge sense of betrayal.
A joint family statement issued today suggests Sherry and Keith Papini are still together. Sherry and Keith have cooperated with law enforcement's request despite repeated attempts to unnecessarily pit them against each other. The statement accused police of ambushing Sherry in a dramatic and unnecessary manner in front of her children.
The family claims Papini would have come to the police station voluntarily if she had been asked.
This hair-raising attempt at concealing drugs was thwarted by authorities in Colombia. They say 2 women tried the same stunt at 2 different airports in the country and were both nabbed. Police say when both women went through airport security, scanners showed foreign objects hidden in their big hairstyles. Authorities say the women were detained and submitted to voluntary scanning, where the images showed irregularities. Video of one of those searches was made public. It shows when airport security officers discovered a vial hidden in the suspect's hair extensions. Its contents were tested on the spot, and police say it was determined to be cocaine. That's when further searching revealed more tubes strategically attached to the woman's head. Colombian police say they seized nearly 2 kilos of cocaine from the women, who were both bound for Madrid, Spain.
Brazen thieves smash a glass door. But you may be surprised to hear what they're after. They broke into a veterinary hospital in Calabasas, California to steal, of all things, parrots. It's the latest crime spree terrifying pet owners. First, it was the French bulldog. You recall 2 of Lady Gaga's beloved pooches were abducted after her dog walker was shot in 2021. Now exotic birds are the new target.
They broke in the middle of the night, and they went straight for the birds.
Cody, Baby Love, and Sweetie were nabbed from Feed Barn in Dana Point, California. 2 men smashed through the front door of the pet supply store holding backpacks.
To be in and out of this store in 1 minute, they're familiar with birds. They know how to handle them.
So how much are they worth?
$10,000 to $15,000 for all 3.
The break-in here at the Feed Barn is one among a number of thefts of exotic birds across the country, having many people wondering if they're related as part of an organized crime ring. In Atlanta, cops arrested a guy suspected of stealing parrots from a local restaurant. The exotic creatures were found in his backyard.
Those look like macaws.
Are you fearful that you will never see these birds again?
I am fearful that I'll never see these birds again. Just bring them back. Like, we just want them back.
You had an Oreo cookie for the first time.
This little boy has just eaten his first Oreo cookie.
And then Blake.
So has his twin brother Blake.
An Oreo cookie for the first time.
Blake definitely enjoyed his Oreo, and the nice long bath, that came later.
Another internet challenge could get some people in a lot of trouble. The Suffolk County Police in New York released this video of people breaking through a fence in East Northport. They say the suspects are doing what is known as the Kool-Aid Man Challenge. It's a challenge started and perpetuated by TikTokers that involves bursting through a wall or fence like the famous Kool-Aid Man did in those commercials for the sugary beverage in the 70s and 80s. But police say this is a crime, and now these suspects are wanted. Anyone with information can call Suffolk County Crime Stoppers at 1-800-220-TIPS.
I literally have to defend my turf now.
Sometime between midnight and 7 a.m., this California man's lawn was stolen. He told KCBS.
I got up in the morning and I was walking the dog, and the dog realized she had no place to go to the bathroom because it was gone.
In front of Brian Michael Stoller's Studio City townhouse, someone pulled up about 300 square feet of artificial turf. The lawn's value? Around $2,000.
It's not worth it to go through home insurance because it'll just raise our policy and stuff. But, you know, I've got a hammer and I've got nails.
Stoller says he has contacted police, but doesn't hold much hope for the return of the fake grass.
And it's probably going to end up not on the black market, but probably the green market.
He's chosen to laugh at the situation and share it with friends on social media, who all seem to be getting a kick out of the sod who walked off with the landscaping. There are cameras on the property, but none were trained on the plastic grass. Stoller says this time he wants to come up with a way to keep his lawn right where he put it.
We used to say if it's not nailed down, they'll steal it, but this was nailed down and they still stole it.
This trio is being sought and mocked for allegedly robbing a Popeyes restaurant. The Beaumont police in Texas released this video of what it calls 3 stooges who went slipping and sliding into a Popeyes with guns. While cops didn't say what the suspects took, it looks like they made their way to the back of the business and pulled things from a safe. Cops want to identify the 3 who are for now being referred to as Larry, Curly, and Mo. While their faces are covered, investigators are hoping someone will recognize them by their distinct clothing. The fall was probably embarrassing, but surely not as painful as this man, who, according to cops in Florida, broke into a Popeyes in Jacksonville several years ago. He seems to need a few moments to recover from the crash before he starts trying to pry open the registers.
A historic Southern California cemetery was looted for its metal. Lincoln Memorial Park in Carson was one of the first racially integrated cemeteries in Los Angeles County. Families have laid their loved ones to rest here since 1929.
As you can see, all of these plaques are gone.
Aisha Woods, a volunteer caretaker at Lincoln, told KCBS thieves have targeted the sacred space because of the bronze nameplates and statues.
I believe that they know a lot about metal because they took some type of liquid to take off some of the patina to see if it is bronze.
Bronze can hold value when sold for scrap metal and melted down. But these pieces of bronze also hold sentimental and historical value. The face of a memorial donated by boxer Joe Louis in 1944 was pried off. It was there for 79 years to honor black soldiers in World War II.
Now, Joe Louis in the Sentinel newspaper, as they described, was here to dedicate it. We won't have that anymore.
Now the long, expensive journey to replacing those plaques and nameplates begins.
That's their name, that's their proof, and now this is gone because somebody wants metal. You know, that's heart-wrenching to me. As you can see, family members that just They are doing their best, and they're replacing it with tape so they know, and everybody know where they were.
Woods and her group of volunteers remain dedicated to the Lincoln Memorial Park, and authorities say they are investigating the crime.
The thought of someone even picking a cemetery to rob any type of metal or gain was utterly disgusting to me.
In the booming sport of pickleball, Rodney the Rocket Grubbs was a genuine celebrity.
Hey, Pickleball Nation, this is Rocket coming to you.
He held clinics across the USA. He was even named the sport's ultimate ambassador by USA Pickleball.
There were actually people that recommended him to be in the Pickleball Hall of Fame.
Today, however, these women are calling him the ultimate con man.
Shame on you, Rodney, for what you've done.
They enjoyed playing pickleball at the Villages in Florida, the nation's largest retirement community. But they all say they were swindled by Grubbs.
I invested $25,000.
I invested $25,000.
I also invested $25,000.
Jennifer Butler says she was taken for about $100,000.
I lent him money 4 times.
Grubbs' pickleball company called Pickleball Rocks sold equipment like nets and paddles. He reportedly got 136 people to invest their savings into the company, and he raised untold millions of dollars from people, many of them elderly, who wanted to get in on the pickleball craze.
That approach really worked for me because I want to spread the pickleball love just like all of us do.
Did he give all of you that song and dance that, hey, there's only a limited amount of spots here?
Yes. Absolutely.
They claim they were promised an 18% return.
There are some people that he actually has their entire life savings. They invested with him, and their entire life is ruined.
Jackie Voss says all she got out of her investment was a T-shirt that Grubbs gave her husband.
I told my husband, I said, well, enjoy that $25,000 T-shirts because that's exactly what that shirt cost us.
Hope I haven't lost my stroke.
Grubbs has not been charged with any crime or securities violations, but he did just receive a cease and desist order from the Indiana Secretary of State, alleging that he committed securities fraud by selling unregistered investment opportunities.
Want you now to meet Donna and Scott. Now, Donna has been helping Scott pursue his secret crush on John.
Jenny Jones was one of many daytime talk show hosts in the 90s that had viewers tuning in to watch ordinary people reveal their deepest, darkest secrets. But one of those revelations would turn deadly.
Man, my sister, I think I just got him in.
Okay, calm down, okay? Okay, why did you do that?
In 1995, The Jenny Jones Show taped an episode on secret admirers. 32-year-old Scott Amador revealed he had a crush on an acquaintance, 24-year-old Jonathan Schmitz. The show brought the two together to see if there was a love connection.
Well, guess what? It's Scott that has the crush on you.
You lied to me.
The audience erupted in excitement, and a surprised Schmitz, while caught off guard, seemed to find humor in the moment.
Did you have any idea that he liked you this much?
No, I did not.
Can you tell us what your status is? Are you involved with anybody, or?
No, but I am definitely heterosexual, I guess you could say.
But the laughter faded 3 days later.
Last Thursday, 32-year-old Scott Amador was killed after receiving 2 shotgun blasts to the chest. The alleged perpetrator of this vicious crime was an acquaintance of his, 24-year-old Jonathan Schmitz.
Schmitz called 911 to turn himself in after he showed up at Amador's home and shot him to death. Schmitz claimed he was humiliated by having been brought on national TV to hear Amador profess affection for him. The feelings, he said, were not mutual.
He said he's gay, but I'm not. He said he wouldn't leave me alone, that's why I did it. He said I went on the Jenny Jones show. I didn't know it was a guy, that's why I killed him.
But the trial also called into question the ethics of tabloid talk shows, which were in their prime. Critics claimed their so-called deceptive practices and sensationalized style were to blame for this tragedy.
The Jenny Jones show ambushed this defendant with humiliation, and in retaliation, this defendant ambushed the victim with a shotgun.
This is a renegade business. These are irresponsible people. These are people beholden, answerable to no one.
The show never aired the Amador Schmitz episode, and Jenny Jones appealed to the public not to place blame on anyone but the shooter.
As much as we all regret what happened, the fact is that this tragedy is about the actions of one individual.
But Scott Amador's family took the show to task, suing for negligence. Like the show, the trial also gripped viewers who tuned in to watch the family's attorney take aim at the host on the stand in an intense exchange.
You used him as a source of entertainment, having no idea what his emotions would be for other people, didn't you?
No, that's not the way I see it. I don't use people on the show.
It's my understanding you have reached a verdict. Is that correct?
Yes, we have, Your Honor.
Was the defendant's negligence a proximate cause of injuries or damage to the plaintiff? How do you answer, yes or no?
Yes.
The Jenny Jones show was ordered to pay the Amador family $25 million, but the decision was overturned by the Court of Appeals. Jonathan Schmitz was convicted of second-degree murder and sentenced to 25 to 50 years in prison. After serving just more than 20 years behind bars, he was granted parole. Schmitz walked out of prison this week. The Jenny Jones show ran until 2003 for well over 1,000 episodes. But its most famous episode was one that never made it to air.
The accusations are sickening. This little girl has spent her entire life in and out of the hospital, hooked up to tubes and monitors, being told she was deathly ill.
I love you, Mommy.
Now her mother, Pamela Reed, is under arrest after cops say she admitted to faking her daughter's illnesses to collect money. It's reminding many of Gypsy Rose Blanchard, a victim of Munchausen syndrome by proxy, a condition in which her mother faked her illness to get attention. Gypsy Rose was just freed from prison after serving 8 years for the murder of her abusive mother. In the case of young Addie Ray, cops in Ohio say Pamela Reed lied to everyone, claiming her daughter suffered from leukemia, seizures, and was blind in her right eye. Reed even created a Facebook page asking for donations with this moving tribute of little Addie's medical triumphs and setbacks. Cops say the deranged scheme was uncovered by a school nurse who contacted authorities. I spoke to prosecutor Jordan Croucher.
Thank goodness this poor child doesn't have cancer, but then that quickly pivots to a very in-depth and thorough investigation.
Here's where the story takes an even stranger turn. Pam Reed is not Addie's biological mother. This woman is.
I am her biological mother.
I spoke to Shadow Peterson today. She says while caring for Addie as an infant, she battled drug addiction.
At the time, Pam was my best friend, my go-to person. I signed Addie over to Pam so she would be safe.
While in rehab, she was told that Addie had cancer. All of it was made up.
Yeah. Yep.
Shadow has kicked drugs years ago and is now an EMT.
What would you like to say to Pam today?
Like, I trusted you to take care of my kid. Come to find out you're the one making her sick. I just don't see how you could ever do this to somebody's kid.
Might you try to adopt her back?
I'm going to try. I'm going to try my hardest. I'm not going to stop fighting.
Powerful stories that change the way you think. Impactful investigations that change the way you see.
How many times has your car been stolen?
5 times.
Yeah. What? Do you think that you're a responsible owner of tigers?
I damn sure do.
Heartwarming moments that change the way you feel.
Amazing.
Now available in a place that changes the way you watch TV. Inside Edition,